now, which means the second class and so on will be recorded. So if there's anything you guys want to review, you have that link. So, share again. When we last left, we were looking at different forms. So we had looked at the additional provisions addendum, and that was the one that gave us, we'll call them commonly used provisions, but just not common enough to make it to the actual 2T, to the actual offer to purchase and contract. I think that additional provisions addendum is one of the ones that we use the most. Specifically, the expiration date, I'm seeing being used a lot in this market, the expiration of offer. And the other thing I'm seeing a lot in this market, or not in this market, but I bet you we'll see again as we get out of this market, is the buyer requesting repairs before inspection. Again, remember, we're attaching the additional provisions addendum to our offer. So basically the buyer's asking for repairs when we're presenting the offer. The buyer wants the seller to take that into consideration when they're taking their offer into consideration. And I think it's important that we remember that that provision does not negate, right here, agreed upon repairs and or improvements. This does not negate the buyer doing inspections and investigations once we're under contract. This doesn't negate the buyer from not being able to ask for repairs once we're under contract. This is just saying, hey, I see this is broke. This is a deal breaker for me. If you don't fix it, we're not going into contract. If your buyer wants to use this, they need to understand, especially again, in this market, it's not going to fly because the seller has 20 some other offers that aren't asking for things to be fixed. But I bet you this is something we're going to see as that pendulum swings back. The other form that we looked at the other day was the due diligence repair request agreement. That was the form that we use if the seller agrees to do any repairs. So now we're under contract. The buyers had their inspections done, their investigations. They've asked the seller to do repairs. The seller says, yeah, not a problem. I'll do that. So we're going to use this form. I will say it again, because I think it's really important that we all hear this. Be very specific when you're asking for repairs on behalf of your buyers. Don't just say fix electrical, right? What is it about the electrical you want fixed? If you can provide that portion of the home inspection that says specifically this is what's wrong, I think that's best. But you know, if you tell me to fix electrical, you have some sellers that would, they'd go change a light bulb and be like, well, I fixed it, you know. So just be very specific in what you're requesting. And then, you know, just as another piece of advice, to ask for paid in full invoices and receipts. We don't want your buyers to have a mechanic's lien put on the property because the seller didn't pay that bill as part of their agreement. Questions about the forms that we looked at the other day, or comments about the forms that we looked at the other day? The other one I want to look at is the agreement to amend the contract. And this is one this was one of the changes, one of the 2022 changes. And the big change that they made on this one is they allow us to say if this is amendment number 1 or amendment number 2, because sometimes throughout the contract to closing process, we may have more than one amendment. So you can specify which amendment this is, so you can kind of keep that in order. Remember we said the other day, an amendment is a change. So an addenda adds, an amendment changes. So we're using this form when we're changing something that we've already agreed to. It starts with a big red warning. All parties, including the lender and settlement agent, must be provided a copy of this agreement. Remember when we went under contract, the buyer's agent sent the contract, the signed contract, to the lender and the attorney. So now that we're changing that contract, we need to remember to send that to the lender and the attorney as well, so they have the current information. This tells us that buyer and seller have entered into a contract regarding the purchase of the sale for the following address. And then you can see here a list of things that we can amend. And as you're looking at these kind of look like the blanks that we fill in the offer to purchase and contract, right? The negotiable points, earnest money, due diligence, purchase price, building deposit. Another change that was made, there was some clarification in the escrow agent. If the escrow agent is changed, we're going to list the new escrow agent. And the escrow agent named in the contract is hereby authorized and directed by the parties to release the earnest money deposit in the amount of X amount to the new escrow agent, to the successor escrow agent. And then the new agent needs to sign acknowledgement of receipt. So we always had a place where you could change the name, but now we need to address getting that earnest money from said agent to this agent. Yeah.
So for an example, would this be for the earnest money to go from the firm to the attorney?
Possibly, if the firm was holding it, if they were the escrow agent, you change. I think where we're seeing this, I think where this came up, Ronnie, what we're seeing is a lot of attorneys are backed up. And so you may think you're starting with one agent in the contract, right? And then you get it under contract and you go to schedule closing and they say, I don't have any time for, 4 weeks after that. So now we got to go out and find another agent.
Right.
So lesser firms are holding the earnest money deposit. I think Tate still does. So you'll get to deal with that.
They do. Yeah.
Your bigger name brand firms still have, but companies that like Deborah and I work with, we're not dealing with the trust account. We're letting the closing attorney, and what we're finding what's happening in our firm is we put attorney A in as the escrow agent. Like I said, and we go under contract, and then we find out attorney A is booked up for the next, and doesn't have time. So now we got to change that agent. And I'm, probably something what this is about. Again, we've always been able to change escrow agents. The newness of this form is the new agent acknowledging receipt and specifically saying we need to get that earnest money from old agent to new agent. We can change the settlement date. Settlement date is hereby changed too. Remember we said the other day that our contract has a 7-day delay built into it. So we automatically have a 7-day delay. We're going to change the settlement day. Maybe it's got to be more than 7 days. Maybe, for example, it's new construction and it got pushed way out. Maybe we're not going to get loan approval, whatever. The thing I want to point out about this, if you change the settlement date, you are adding another 7-day delay, right? Every time you have a settlement date, you have another 7-day delay, unless you check this box. If you put in a new date and check this box, now you don't have a 7-day delay, you have a 4-day delay. So without the box, it's 7, with the box, it's 4.
What was the purpose of that?
Some sellers may not have wanted to remember this, it was 14 days, right? So some sellers may not have wanted to give that much more time. Maybe they didn't have that much more time to give. So maybe if we could say, okay, all right, instead of 7, we're only going to say 4, then that may make the seller more apt to, I hear you, but that may make the seller, because what if they terminate? Now they got to start all over, right?
All right. All right. We got 3 days. We got 5 days. We got 7 days. We got 10. Now, this is the only rule I've ever seen with 4.
Just to throw a wrench in it for you. I know. Expenses, the amount the seller is going to pay towards the buyer's closing expenses. I think this is sometimes used when we're negotiating repairs. Maybe the seller wants to help out, but they don't want to do repairs. So they say, okay, you know what? We'll just pay, $1,500 toward closing expenses, whatever.
Or the buyer may be wanting to use their own contractor.
Exactly. The buyer's using their own. If we're going to renegotiate and add in a home warranty or take it out. This was fairly new as well, the home warranty. And then our usual buyer signs on the left, seller signs on the right. Agreement to amend. Questions on this one? Other than why 4? I know. I don't have the answer. I took a class with NCAR a couple months ago, and the lady that taught it was on the forms committee. And I thought, that's the lady I want to sit down and have lunch with, chit chat with. But she told us, she said, guys, the forms committee does not get together and make these changes to make your lives live in hell. That's not our purpose. We do these changes. We have actual reasons that we do these changes. And I thought that was cute the way, because I thought, I bet you the forms committee does get a lot of grief about why they do what they do. All right. So let's pick back up where we left off when we went off PowerPoint. Again, we're still in 14, kind of working through the buyer's due diligence process. So you remember on Monday, we talked about various inspections, things that the buyers should consider inspecting and investigating. We talked about the importance of them getting that loan pre-approval early. We talked about the importance of us not putting them in our cars, or us not taking them out and showing them property until we know they can buy the house, until we know that they can afford it. They've at least had a conversation with a lender. The last thing that we said before we got off PowerPoint, again, I'd like to start here just because the Real Estate Commission does call this a major problem topic. Any agreed upon repairs have to be in writing and signed by the expiration of due diligence, 5 p.m. of the due diligence date. The repairs themselves don't have to be complete until settlement or what other arrangements the parties have made. Comments or questions on this? What do you guys feel about the due diligence request that comes in at 4 o'clock on the due diligence date? Buyer's agent sends due diligence at 4 p.m. and due diligence is up at 5.
I don't think it's a tactic that the buyer maybe wanted to play games with the seller and throw them all off. Seller thinking everything's going fine. Oops.
Well, I don't know that it matters, because they had their due diligence period, regardless of when they finish that up. I would think that it's to the seller's advantage the other way, because they're not required to do anything on that. So I feel like if anything, it limits the buyer's negotiating room back in case the seller did want to
What if they
give
did?
a little bit.
Yeah, I think that's a fast way for a seller to say no, isn't it? Because what if they want to talk to their electrician? What if they want to talk to their plumber? You didn't give them any time to barely look at the report. And I agree, Deborah. I think it's a hard no, a fast no. Ronnie, I think you're right too, from the seller's perspective. This whole time we've been thinking everything's going okay. And then all of a sudden here we are down to the 11th hour and what they want to do this and this. Again, prior to this market, a trend that was starting, I think a couple agents were trying to do this, but I was seeing it a little bit. When agents were sending the due diligence repair request, they were also sending the termination of contract. And they were basically saying, tell your sellers to sign one or the other.
Okay. And if
Isn't
I've
that
got
a hard
that,
sale?
and if I've already deposited that $10,000 check, I might say, hey,
And I think that's why it went away when those due diligence fees started coming up. Now, this was back in the day when they were like only $500. You know what I'm saying? Now the buyers got some more skin in their game, right?
Yeah.
But yeah, I knew a couple times that happened, and I thought, wow, that's pretty brazen to put that out there like that, And sometimes the sellers would sign that termination. The agent would be like, oh, no, we're good. We're sorry, the termination's already signed. So we're done. So, sometimes I think we're helping our buyers. We're saying, we're going to give the sellers an option. Either they fix this or we terminate. sometimes we call their bluff, don't they? And sometimes that doesn't work out. So is that the tactic you want to do? I don't think it's up to me. I think it's up to the buyer, and it's up to their risk level. Are you prepared if the seller signs the termination? Are you ready for that? Because if I send both, I'm giving them a choice. And if they send back this termination, are you ready for that? Okay. Something else we're going to do while we're under contract, hopefully, while we're in due diligence, is try to get our hands, assist our buyers on getting their hands on covenants. If it's going to be in an HOA or subdivision, we want to get covenants. Sometimes you see them loaded in MLS. I think that's oh so very helpful when the listing agent provides them. Some homeowners associations won't talk to anybody but the owner, the homeowner. So they're not going to talk to the listing agent. They're not going to talk to the buyer or the buyer's agents. They're all different. But we need to help the buyer obtain them. And I think it's important that we understand that when it comes to covenants, my job is not to interpret them for the buyer. My job is to help the buyer get their hands on them. Once the buyer gets them, if they have any questions, then I need to refer them to our closing attorney or the HOA. Particularly if your buyer wants, your buyer wants to put up a fence or a storage building or, pool. If it's in an HOA and they have a specific need, then we need to make sure it's allowed. And like we said the other day, don't tell them it's okay because that's what the neighbor's doing. Just because the neighbor has a fence up doesn't mean that the HOA allows it. They could be in the throes of that lawsuit right now. They could be being fined X amount every single day that fence is up. Zoning, if your buyer, again, has a particular use. Maybe they want to run their, maybe they want to convert their garage into a hair salon. We have a duty to make sure that zoning allows that commercial business in the residential. Zoning is a material fact in Triad MLS. I'm going to rephrase what I just said, erase what I just said. It's not a material fact. It's a required field. So in other words, we can't input a listing in the Triad MLS until we have the zoning. For the most part, buyer's agent should be able to rely on what's in MLS. But if your buyer has a specific need, or if you have any reason for a flag to go up, then as buyer's agents, we need to investigate that and help the buyer learn what the zoning is, what is and is not allowed. If something is zoned single family zoning, how many families are allowed to live there on that property? Single family? Just one, right? Multifamily, you could have 2 or more. So let's say it's zoned single family and there's a apartment over the garage, and you hear your buyer talking about renting it out to a Wake Forest student. Should you have a little flag goes up? Because that Wake Forest student, unless they're part of their family, unless they are their kid, that Wake Forest student constitutes a multiple family situation, doesn't it, on that property? So we got to listen. I think that's the point I'm trying to make. People will talk. That's not the problem. People will talk. We have got to listen to what they're saying. Buyers don't know that zoning, multifamily or single family zoning matters. Roads and schools, if the roads are public or private, we can always check with DOT. We also probably want to check with DOT anyway, especially if the properties around one of the couple new beltways we got coming in our area, new proposed highway. I mean, y'all know we don't have to go far in the Triad to find construction somewhere. So if it's going to impact that at all, even proposal stuff that we haven't seen the equipment out yet, we always just kind of want to verify DOT. And then when it comes to schools, I'm a big fan of being the source of the source. So in other words, when my buyers say, I want my kids to go to this school, great. Let's go to Winston-Salem Forsyth County Schools website and let's make sure, let's have them contact the school board to make sure they can get their children in the schools that they want them to be in, if that's something that's important to them, of course.
Julie, I just thought about something. I'm 54, and this is the first HOA I've ever paid in my life. I've always
Okay.
had more rural properties. So one of the, it's 36 houses. It's, it's kind of a gated little community, neat little thing. But one of the things is you're not supposed to run a business where there's any traffic flow. So if
Okay.
you just have a home office, but you're not having people come in and out.
Real estate,
Well,
for example. Yep.
Yep. So here's a good one. Got one of the guys that's doing an Airbnb. And the HOA is not liking that. And they're butting heads. But I never thought about Airbnb actually being a business.
But technically, because they're making money, and technically they got traffic coming and going, don't they? So it might just be like one family at a time, but it could be a different family every weekend or something. So
yeah, I mean, nobody would ever known if what an unusual car every now and then. But I never thought about an Airbnb as being that would infringe upon that. But technically, yeah. But that's why they're battling.
Yeah, right. I was going to say they both probably have really good attorneys, and for the homeowner's attorney, well, it's not like I have, traffic, I have a car a week, which is no different than if I were living here, so
it'll be interesting to see how it turns out.
See how it turns out. And depending on who wins, you may see some amendments to your covenants, because I think a lot of HOAs are starting to go in and specifically saying no Airbnb. Some HOAs, and I don't understand how they're getting away with this one, but some HOAs are coming in and changing their covenants to say no investor owned properties.
Yes.
They don't want investors scooping them up.
Well, this particular one out of the 36, they've got it limited to no more than 10%, which would be 3 houses.
Okay. So they were ready for that before this market. So interesting. Yeah, that'll be interesting to see how that plays out.
But that was something, 10 years ago, nobody ever heard of an Airbnb.
Exactly. Yeah. Yep. Okay. Let's talk about the attorneys. With the closing attorney. We know that they do. Well, let me back up for a second. The buyer hires the closing attorney. So the closing attorney represents the buyer. If the buyer has a lender, then the closing attorney represents the lender as well. And one of the things that the closing attorney does for their buyer and lender client is a very thorough title search. So the attorney is going to do a search of the public records. Part of their job is to make sure that they're handing their buyer client legal and marketable title. The attorney, this is public records. So, I mean, technically, couldn't we all search the public records? Couldn't we all go out and find this information? Sure. So why is this the attorney's job? Because they're the ones that offer their title opinion. And we'll talk about that in just a second. Offering title opinion is what we cannot do. Only the attorney can. So the attorney's going to go through and they're going to find good record of title. They're looking for any encumbrances, such as liens, easements, encroachments. They're looking for any recorded deeds, who is the owner of record, all outstanding deeds of trust, judgments, title defects. You may remember the Marketable Title Act says that if the attorney can go back for 30 years and not find any issues, then the Marketable Title Act says that they can market that title as good, clean, marketable title. If the attorney finds any defects on the title, then the attorney is going to get with the seller to clear these up before settlement. Obviously, if there's any liens, the seller will pay for those liens from the proceeds of the sale. So before the seller gets paid, they pay off all those liens. The attorney's gonna record all those lien cancellations. Everything has to happen in a date, and not a date, but a time stamp. We want to have old liens paid off before we record a new deed, and then record the new deed of trust, the new lien. So the attorney works with the seller to cure anything. Maybe it's not paying off liens. Maybe it's something that, came up from, I don't know, 25 years ago. If, it's something that the attorney can't clear up themselves, then they and the seller will go stand in front of the judge and get the judge to fix it, if possible. But what we need to understand is that the title's got to be clear. It's got to be clear and cured before the seller can pass it on. And probably one of the bigger concerns that we have is that mechanics lien. Again, asking for paid in full invoices when the seller agrees to do repairs, or if the seller does any work to the property before they list. Maybe you tell them to have the landscaper come out, curb appeal is everything. So have the landscaper come out, let's paint the front door, whatever. And we do some work on the property before we list it for sale. We want to make sure that those are paid in full, so the new owner won't have a mechanics lien hit after they close. Who remembers how many days the mechanic has to file the lien after the work ends? How many days? There's another day for you, Ronnie. It's more than 4.
Yeah, I want to say 60.
A little bit
60.
more than that.
90? 120.
120. So the mechanic has 120 days to file the lien from when the work ends. And you think, especially in this market, we list it, go under and contract and close it well within that 120-day window. So typically, I think, even pretending that we're not in this market for the moment, I think where the concern with this is any agreed upon repairs. We want to make sure that those agreed upon repairs are paid in full, so the new owner doesn't have that unsuspecting mechanics lien. What happens if the seller lies? What happens if the mechanic comes back afterwards and file the lien? That's where your new owner has title insurance. And we'll talk a little bit more about that in just a second. We mentioned the other day, I think we're good with this. If a buyer buys a property with a lease, with a tenant in place, they're going to buy honoring that existing lease. And part of the buyer's due diligence should be to review all leases during the due diligence, any statements, security deposits, records, financials, anything like that. Remember too, we have a provision in our additional provisions addendum about this very situation if the buyer buys. And something that needs to be determined is that tenant security deposit, and how we're going to get the security deposit from the seller to the buyer, from the old landlord to the new landlord, if you will. Seller and buyer have to figure out how the buyer is going to get that security deposit at settlement. And there's a couple options that they have. They can either have the attorney assist in transferring it from the seller's trust account or escrow account to the buyer's. If they're unlicensed, it could possibly be in a bond. So we just need to somehow transfer that from old to new. Probably the least popular way to do this is to return the security deposit to the tenant. And then once we close, let the new landlord go to the tenant and say, okay, I need security deposit. I think Ronnie's laughing. I think we can kind of see the issues that could.
Yeah, good luck with all that.
Exactly. So I think usually what we see is we have buyer and seller, and we just have the attorney, we got an attorney sitting right there anyway. They're helping us draft up a new lease, do an assignment and draft up a new lease. They're there. So why not have them help getting security deposit from old to new?
And since security deposits are not income, they're not prorated at closing.
That's exactly right. That's exactly right.
In that second scenario where the option would be to return it to tenants and then go back as the new landlord to establish that, if if they are under a lease and then those tenants fail to follow back up and redeposit the deposit, would that then the new owner give you reason to start eviction No, I
I
guess
would
you
think
could
so, because we got a violation on, because when we got a new lease.
Cause you
That
just
says that, and
assigned
it
there.
probably says this, that the security deposit is due by this date, so I would absolutely think so. It just gives me a headache to think about.
But if they're assuming the leases, then you don't have a new lease, you just got a new owner.
Well, you're right,
Assuming
we're
the
not gonna
existing lease.
change, so we do just have a, yeah, you're right, but they still owe that then, right? No matter if they owe, back then or now, so see the headaches that could cause. So yeah, let's just let the attorney do it, if that's what the parties can agree to. But yeah, you're right, because the only thing that would change would be the name of the landlord. But you would have a new lease signed starting today, so I wonder if the attorney could have,
Would you technically have a new lease, or would it be more of an assignment?
it would be an assignment, but the attorney is probably going to draft up a new lease. They're probably going to have at least plug in the new name, right? I don't know if they'd make the tenant sign anything or not, but at least put in that new name. These are great questions. I honestly don't know how that could happen. But yeah, I mean, your rent's going to stay the same when it's due, the term of the
Right.
lease, all that stays the same.
Because to me, it appears more like if your mortgage gets sold to, a different mortgagor, it really doesn't affect the terms of anything.
Exactly.
So to me, this kind of would fall under that same kind of legal category.
Yeah, you're right. Because, I think I told you guys the other day, my mortgage just got serviced and I didn't have to sign anything new. I got a letter saying by the by, so yeah, you're probably right. And be up, so if the tenant fails to send that security deposit to the new landlord, I would think that they would have a case, Deborah. I think we went a long way around that, but yeah, I would think they'd have a case because the lease says you have X amount of security deposit.
I still agree. I do still agree, though. It's cleaner to do it at closing and have it transfer from one to another.
Yeah.
And not have to worry about you returning it and then they go spend it. And then you're in this legal battle all of a sudden, which you, as the new landlord, are now going to incur legal expenses to pursue that. So I feel like if you ever run into that with a new buyer or what have you, I would think the recommendation to my buyer would be, let's see if we can establish this at closing.
I agree. I agree completely.
Wanting to get them into that legal.
I mean, well, we're still waiting on the ink to dry, right? They could already be facing. It seems awfully early in that home ownership to be dealing with stuff, for sure. Good. So let's go ahead and take our first break. We're still working through the buyer's due diligence. We're going to talk a little bit about earnest money when we get back. So let's take 10 and we'll keep going in chapter 14. All right.
Julie, if you're wondering what I look down at, here's my old dog laying right beside my desk
Aw,
in the office.
she's just chilling.
Yeah. Best
He or
kid
she?
yeah.
She.
Her name's Radar.
Nice.
And someone abandoned her when she was 7 weeks old on a snowbank outside of one of my factories.
Oh.
And she was the ugliest puppy ever.
Oh.
I have evidence.
Oh.
But that's terrible.
Oh, this is cute.
But she came around. Let's see her. What's a good picture?
How old is she now?
She's old. She's almost 13.
Oh my
So
goodness.
So she's getting all gray. Let's see here. Oh, here's a good one. That's her.
See, she grew out of it. Yeah.
Oh, yeah. She's a great one.
Oh, that's awesome.
But yeah,
Sounds like she found you.
she did. I had over 500 employees at the time, and I went around to all of them trying to get them to take her, but she was too ugly for any of them, so I didn't want her to freeze. And
and here we are.
Here we are, my constant companion.
That's sweet. And she's chilling in the afternoon.
Yeah.
All right. Let's talk a little bit about earnest money. We are going to define earnest money and talk more about it when we look at our contract in chapter 11. But just a couple of things about it now. We're talking about that pre-closing, getting ready for closing. If the listing firm is holding the earnest money, the commission rule says that the earnest money cannot be transferred from the firm to the attorney no earlier than 10 days prior to settlement. Now, this is only obviously that the listing firm have it. If the closing attorney is holding it, they already have it, right? So we don't have to worry about transferring it. They already got it. So if the listing, so Ronnie, this is going to apply to you. So if the listing firm holds it, and when you start doing your training, they'll tell you about how to request it, when to request it. They'll tell you how they want you to handle that, getting that money from them to the attorney. But the commission rule says no earlier than 10 business days prior to settlement. Again, if the listing firm has the earnest money, there's one of two ways that we can do this. Either the broker delivers the check from the listing firm to the closing attorney. So you go to your firm, you say, I got a closing next week, I need earnest money. They say, great. They write you a check to the closing attorney. You pick it up from your office and you take it to the attorney's office with you when you go. Or, and I think we're starting to see this more common, instead of that money being touched by so many people, another option we have is that the earnest money stays at the listing firm. And when the broker gets their commission check from settlement, their commission check is whatever they're supposed to get minus the earnest money deposit. So basically what we're saying, let's say that your commission is $3,000 and the earnest money is $1,000. The check that you pick up, the commission check that you pick up from the closing attorney after settlement is going to be for $2,000. Does that make sense? So then you take that check back $2,000 to your office. Your firm transfers the $1,000 earnest money from the escrow account to their operating account. And that's how the firm gets their whole commission. It's
does that not make the bookkeeping a little messier though? Because I mean, how is the firm now keeping proper check of earnest money across many trust attorneys and our closing attorneys as well as commission? I feel like that would be messier. Why can't they just do an electronic transfer from the firm bank to the trust account in like a wire?
Maybe they could. Maybe that's something, if the attorney will allow it and the listing firm will allow it, you know, I don't think there's a wrong way to get to it. We're just saying these are the two most common ways that we're seeing. And this second way that we're talking about is newer. And I feel like we're seeing it more frequently, because I mean, all the listing firm has to do is, like we said, just transfer it from escrow to operating, show that earnest money left escrow, which they have to do if they cut a check or send a wire transfer anyway. So there's not really an extra step there for the firm. And then, you know, you don't have somebody cutting the check, an agent transferring the check, and then the attorney has to deposit the check, right? You don't have all those extra steps, all those extra hands on it. So, you know, wire transfer very well may be an option. But I think the point being is that if the listing firm has the earnest money one way or another, we got to get it to the closing attorney. They have to have that as part of their funds.
So doing it this newer way, is that the attorney's call that it will be handled that way, or somebody's got to make that decision?
Somebody's got to make that decision. That could just be up between the firm and the attorney, right? How are we going to do this? Yeah. I worked for a bigger brand a couple years ago, and when they started doing this, and unfortunately I wasn't around with, you know, how do we do this? You know, the attorneys have run everything through a trust account anyway. So when they pay me and you and the home inspector and the lender, that all comes from their trust account. So for them, that money is there already, or, you know, is part of it. They just would take that from the settlement, from the proceeds, and have it in there already. So, yeah, maybe not one right way to do it, just so long as it happens, just so long as that money gets there and is accounted for. When we do our closing disclosure math, we'll talk about this again, because this is kind of math that we need to see if we're going to do it this way. How does it look on the settlement statement? So we'll see how that, because to Deborah's point, you got to account for it, right? You can't just have $1,000 floating around out there. So we do properly account for it on the settlement statement, and we'll see that when we get to that in just a bit. Getting closer and closer to closing. We're getting there. As we mentioned early, the attorney is the one that arranges for title insurance. So the attorney does the thorough title search right before in between settlement and closing, that period in between settlement and closing. The attorney will offer their opinion on the title, and based on the attorney's title opinion, title insurance will then issue insurance to protect the new owner. If there's a lender involved, there's going to be two policies, one that protects the owner, one that protects the buyer. I really need to edit this, but I think it's important that we realize title insurance, when we say buyer, it's actually an owner's policy. Because once title insurance protects the buyer, they're now the owner of the property. They're not protected until they own. So it's two policies. It's an owner's policy and it's a lender's policy. The owner's policy will cover the new owner for as long as they own the property. The lender's policy will protect the lender for as long as there's a loan. So as long as there's an outstanding mortgage. Once that mortgage is paid off, the lender's out. And think of title insurance as errors of the past. We're protecting the owner, we're protecting the lender from anything that the previous owners did, errors of the past. So let's go back to that mechanic lien. We do a repair, we don't pay that bill, we go to closing. 119 days later, the mechanic files the lien. Now we have a lien on the property. Title insurance will go after the previous owner because the seller signs something at closing saying this isn't going to happen. They sign an affidavit saying, no, I've paid everything. There's no way a lien can hit the property. So if a lien does from before the owner owned, Title insurance will go after the previous owner first. And if they can't or won't, if they're, broke or dead, whatever, then title insurance will protect the owner. Closer and closer to closing, we need to notify the buyer the money that they need to close. That's part of the reason why we're doing settlement statements here in this class, is because we need to be able to make sure when we're working with buyers, we need to be able to make sure that the money that they bring to closing is accurate. So we're going to help them look at their figures, make sure everything is accurate. The money that the buyers bring to settlement have got to be readily available funds. We either need a wire transfer or a cashier's check. They can't bring a personal check to closing. Nobody wants to wait 10 days for that thing to clear the bank, or 5 days or whatever. So we need readily available funds. Whether or not you do certified funds or wire transfer may depend on the attorney. Some attorneys may say anything over $25,000 will only accept a wire transfer. So if you're not familiar with this attorney, you've not worked with them before, just pick up the phone and call them or their paralegal, and find out if they have a preference, how your buyer brings those readily available funds. Same thing if this, go ahead.
All right, if the buyer brings certified funds to the closing, seller last second before closing backs out, how does that buyer get those funds back into his account?
I don't know. Is there not a way to return a certified check?
I don't know.
Yeah,
that's a good question.
That would be a really good question for the bank, right? What happens if, a wire transfer, it might be that the attorney has to deposit it and then turn around and write a check back out to the buyer, right? Because the certified funds will be made out to the attorney. So it might be
Very
that that's
good.
what
Okay.
I'll deposit
makes
it
sense.
and then, write you a check. And it's readily available funds, so I don't have to wait for it to clear. Because could that happen? Sure. There have been cases where the seller just is a no-show. If you guys haven't already, get on some of these closed Facebook groups that, there's like Triad Agents, and there's some other good ones out there, but there's some, I like them just for the stories. And there was one not too terribly long ago. I don't think it was around here. I think it was a national one. But anyway, the agent said their seller was a no-show for closing. And they called and went by the house and went by their work and couldn't find, they had gotten arrested that morning. And so they were sitting in jail. So you never know, right? You never know what might happen. Could you imagine this poor person standing in front of the judge going, but I got to go sell a house, so things can happen. Same thing on readily available funds. If the seller has to bring money to settlement too, if the seller's underwater and they owe more than it's worth, and they may have to bring money, that too needs to be readily available funds. Hopefully the listing agent has had this conversation well before closing. Hopefully the listing agent had this conversation with the seller before we ever listed the property, when we were looking at our listing agreement. The loan closing package and document review. So we're going to talk about delivery of the closing disclosure from the lender to the borrower. We will discuss that in just a minute. Once the borrower signs off on it, then the lender and the attorney or the paralegal kind of get together and put their finishing touches on things, make sure that they have everything that they need. Once that's finalized, that's usually when the paralegal sends us the closing disclosure. So we don't get the closing disclosure from the lender to review. We usually get it from the paralegal. The lender tells the attorney how they want their loan package handled, how they want it addressed, how they want it signed, The lender is the one that's kind of in charge here, letting the attorney know how to handle it. They send their instructions, etc. Once the buyer signs that loan package at settlement, the attorney sends it back to the lender to approve. So the lender will go through and make sure everything is signed, all the I's are dotted and the T's are crossed. And upon satisfactory completion of the loan package is when the lender releases the funds. And they will usually send in like a wire transfer to the attorney's office, but they're not going to release those funds until they see their loan package is signed. There have been a few occasions. Again, always tell your parties to have a plan B. You may also want to tell your parties, once they leave the attorney's office, don't go too far, because there have been occasions where the lender has said, this isn't signed or dated or initialed, or this form wasn't complete. And before we can do anything else, before they release the funds, the attorney's got to get the buyer back in to finish up what what was overlooked. So I try to keep my buyers close, just in case they have to go back and, wouldn't that be horrible to delay everything a whole day because we didn't get your initials on page 632 or something, you know what I'm saying? So keep them close just in case. Again, our duty to review the closing disclosure, that's where we're heading. That's why we're doing the math that we're doing in this class. There's a couple different types of closing method states. Other states may use an escrow closing method. We do not do this here in North Carolina. Or let me rephrase that. It's not common in North Carolina. The escrow closing method is performed by an escrow agent, not an attorney. The parties usually don't attend. They just kind of drop their stuff off. And once the escrow agent has everything, that's when they process it. They use something called the relation back doctrine. And that just says that the deed is considered delivered once the seller has given it to the escrow agent. Once they have signed it and done their thing, they give it to the escrow agent, and that's when the deed has been considered delivered. I think this is important because the majority of states are an escrow closing method. So it's really common to have buyers moving from another state and at some point look at you and say, do I have to hire an attorney? I bought a house in Missouri or Michigan and I didn't have to hire an attorney. If you're purchasing a property in North Carolina, then yes, because in North Carolina, we are a settlement meeting method, which means our closings are conducted by real estate attorneys, by closing attorneys. I recently found out, it just blew my mind because I didn't know anything other than this. I didn't know anything else existed. But guys, we're only like one of 6 or 7 states that still do the settlement meeting method. So the majority of other states out there will do the escrow meeting method. And New York, I know, is one of them. And you're going to have buyers coming down from New York and say, why do I have to pay for an attorney? Because you're in North Carolina. And that's how we do things here. We'll see this again in our contract as well. Non-lawyers can have a role in closing. So these could be like the paralegals, for example. As with our unlicensed employees, there are certain things that the non-lawyer can do. They can present and identify documents. They can show parties where to sign. The attorney is drafting the documents, but the non-lawyer, the paralegal, can show the parties where to sign. They can make sure everything has been properly executed. They can go back through and make sure everything has been dated, initialed, and signed. They can receive and disperse closing funds. Again, the attorney has a trust account that they run everything through. So the non-lawyer, the paralegal, can have access to that and maintain that trust account, receive and disperse funds. And of course, the non-lawyer has to avoid performing unlawful practice. There is a place, I just like to point this out, not to give you guys any ideas, certainly not. But if you'll look in your book on page 471, there's a little section there about closing coordinated by a real estate broker. Let's agree not to do that. Brokers should note that the bar ethics opinion allowing settlement meetings to be conducted by non-lawyer assistants acting under attorney supervision should not be interpreted to mean that the brokers can conduct closings. While broker may infrequently be called upon to coordinate aspects of closings, a transaction they have brokered, brokers are strongly discouraged from attempting to act as a settlement agent. A broker acting as a settlement agent will be held strictly accountable by the Real Estate Commission for assuring that all aspects of closing are handled properly, and the broker uses an attorney to perform all closing functions that require a law license. I don't know what activities we may be infrequently asked to do, but what I do know is we have an attorney, let them do their job. We need to stay away from that. We need to stay away from performing that. I always find that interesting that they have to remind us of that. The non-lawyers at closing, what can't they do? Well, they can't offer the opinion of title. That's the closing attorney's job. They can't explain the legalities of title. Non-lawyers can't advise people how to take title. If you're working with unmarried buyers, for example, you guys are not going to whip out your pre-licensing book and explain Tennessee and common and joint tenancy to them. I cannot tell people how to take title. If you're working with an unmarried couple, then we know that we need to get those buyers to the attorney and let the attorney explain the difference in joint tenancy and tenancy in common. Let the attorney advise them on how they should take title. And only lawyers can draft legal documents, legally binding documents. Comments or questions on that, non-lawyers? I'll tell you guys, you know, we like good attorneys, but I'll be real honest with you. It's been my experience that for the most part, we don't deal with the attorney until we're sitting at the settlement table. Up until that point, we're pretty much dealing with the paralegal. So I think it's not only important to have a good attorney, but I think it's important to have a good relationship with the paralegal as well, because that's who we're pretty much dealing with from contract to closing. There's been many a times that I've never talked to the attorney until we sat down at the settlement table. So just kind of keep that in mind. You know, they're in the background doing the work, but their front line, their first line of communication is that paralegal. I've had attorneys that I didn't use again because I've had such a unsatisfactory experience with the paralegal, you know, so I think that can kind of make or break the deal. So who attends settlement? Well, you got the closing attorney. The closing attorney could send the paralegal with stickies on paper to say, you know, sign here, sign here. They could, because they've drafted it. Again, my experience, I've never had a closing without the attorney present. If at all possible, we want the buyer there. There may be circumstances where the lender allows the buyer to do a mail away closing. That's going to be between the lender and the attorney. The lender has to prove that. I think a good example I had as circumstances that required a mail away closing. I had two buyers, and when I got them, they were active military. And when I met them, she was currently stationed in Italy and he was stationed in Japan. And so we were out looking at property. I was videoing properties for them on my phone. We're working on 3 different time zones, you know, so we were trying to work with those challenges. We went under contract. They did get to come home and see the property while we were still in due diligence. I can't tell you the load that took off of me. That made me feel a lot better that they were actually able to walk in the front door while we were still in due diligence. But then he had to go back to Japan, and she got transferred. She came back stateside and was in Maryland. So the plan was for closing, she was going to get power of attorney from him, and she was going to come down from Maryland and sign on behalf of both of them. Guess what happened the day before closing? Her sergeant said, "You can't go. You got to stay here." So that was a circumstance that the lender allowed us to do a mail away. They FedExed the paperwork to her. She had a notary there on base. that she was able to sign everything in front of a notary and then she overnighted it back to the attorney. I don't think that that shouldn't be the norm, right? It's got to be some kind of circumstance like that. So if at all possible, we want the buyers there. Buyers agents, we need to be there with our buyers. I mean, my goodness, we've been with them since day one anyway. Why wouldn't we go to closing and make sure that this thing got finalized? Interestingly enough, pandemic, attorneys wouldn't let us in. When the pandemic hit, attorneys wanted signing parties only. I get it. They didn't want a bunch of people in their offices, right? Touching their stuff and breathing on everything. So agents weren't allowed. And that was weird for us because as buyer's agents, that's what we were trained to do. That's what we did, always done. And now all of a sudden they're saying, no. I heard cases of many agents, they were sitting in their car in the parking lot of the attorney's office while their buyers were up there signing. They were close to them as they possibly could get. And had their phone handy in case they had any questions. So we got through it. And I think for the most part, we're allowed back in now. Occasionally, you may still have an attorney say signing parties only, and we just have to work with it. We just have to work around it. Sellers may or may not attend settlement. Sellers have choices. They can attend and sign their paperwork and drop off their keys. Or they could sign everything ahead of time in front of a notary and have their agent deliver the paperwork and drop off their keys. I think it comes down to the seller. Some sellers want to see this thing to the very end. Some sellers are so done, they want to be done and they don't want to do it anymore. What do you think, Ron?
Well, my last two that I sold, I didn't attend the closing.
You didn't go?
Yeah, the last one, it was too early to get the dog up. And be somewhere down in High Point or whatever. And then the one before that, I was actually in the Sky Club at the Dallas airport, and we closed it by fax.
Yep. So there you go. I think we just lost Deborah.
Oh no.
Oh no, that's just you and I. I think, from my experience, it's come down. I let my sellers make that choice. Do you want to come? If not, I got it. I got it taken care of. Here she comes. So I mean, I had a seller. He was adamant. I mean, he even signed everything ahead of time. But guess who still showed up at the closing? So he just, hey Deborah. So he just wanted to see. He just wanted to see that it got done. You know what I'm saying? So I think whether or not sellers attend, now again, post-pandemic, you might have some attorneys that say you can just drop it off ahead of time. We don't want you in here, so there's a lot more going on now than what there was 3 years ago. But I think bottom line, it just comes down to the seller. Like you said, you didn't want to deal with it. It wasn't worth it to you. You knew you could do your part before, when you entrusted your agent to deliver the documents and drop the key off. So
yeah, and then later that evening, just stop by the real estate office and pick up a check.
I mean, it was so easy for you, So I think it just depends. And then the other situation when you were in Dallas, I mean, you didn't really have a choice. You couldn't attend, but they still got you taken care of. They still got it taken care of. So if your buyer is pre-pandemic, I don't really know how it's working now, but if your buyer is using a local lender, the lender may attend settlement as well. Now, if it's a big national brand that's headquartered in like Texas or something, you're not going to see them. But if it's a local lender, then the lender may come as well. That's just a conversation for you to have with the lender if they're going to attend. But sometimes they like to come to support the buyers. If there's any questions, then they're sitting right there with us, making sure that our buyers get through it. I think buying a house is very nerve-wracking. And, when I bought my condo, it was 2006, and I was young. I was probably mid-20s, something like that. And it was nerve-wracking for me. I'm getting ready to make this first-time home buyer, and I'm making this 30-year commitment. And I haven't even made that commitment to an individual yet. I was single and enjoying life. And I will never forget the morning I got out of my car at the closing attorney's office. I swear when I got out of my car, my knees turned to jello. And I thought, what am I doing? You know? And about that time, I looked up in the parking lot and here comes my agent, you know, yoo-hoo, you ready to do this? And she, just her support, her being there, you know, helped me get through that process. It was very nerve-wracking for me. I was making a big commitment and I wasn't sure if I was ready, but ready or not, here I was, you know. So I think sometimes for buyers, just having a familiar face, that comforting face that they've been with through this whole process, the person that started with them, I think if nothing else, if we can offer them support, I think that's huge in some cases. Location of settlement doesn't matter. It does not matter. Most of the time we have settlement at the attorney's office. The buyer's the one that should choose where settlement is. So if the attorney has space available, I've had closings at the conference room at the real estate firm. There's an attorney in Greensboro that works out of her house. Even before the pandemic, she worked out of her house. And so we've done settlement at her dining room table, right? Location doesn't matter. It's as long as we have that legal paperwork and somebody, the paralegal or the attorney, are there to make sure that all that legal paperwork is properly signed.
Yeah, my first closing for the first home I bought, we did it in the bank.
You did it in the bank office?
In the
There you
bank.
go.
Yeah.
Yep. So yeah, I mean, the buyer's generally going to choose. It may depend on what the attorney has available, you know. So you can close anywhere, doesn't matter. Trunk of a car, doesn't matter, as long as you have the people and the paperwork, right? So it's settlement. We briefly mentioned the difference in settlement and closing. We'll define that a little bit better when we look at our contract in chapter 11. But the settlement, we're reviewing, the attorney, is reviewing the documents. The attorney is making sure that everything is signed properly. Buyer has brought in their funds. The seller, if need be, has brought in theirs. We have something called the North Carolina Good Funds Settlement Act. And basically what this says is that funds will not be dispersed to anyone at settlement. You and I are not going to get paid at settlement. The attorney, the lender, the home inspector, nobody's getting paid at settlement. We don't get paid until it's a done deal. And it's not a done deal until that new deed is recorded. And that's what our Good Funds Settlement Act says. So let your sellers know, you know, let your buyers know. This, just because we go to the attorney's office this morning doesn't mean that's when it's going to be finalized. Us going to the attorney's office is just one step in the process. So let them know, and for us as well. Don't think you're going to show up to the attorney's office and get your check. You're probably going to have to go back later after it closes and pick your check up then. I had one attorney in Greensboro. All my years, I had one attorney. I was with the buyers, and he's in Greensboro, and they signed everything. And he said, can you guys, the attorney said, can you guys hang tight for about 10 minutes? And I said, we can. He said, give me 10 and I have you out of here. And he came back 10 minutes later. He recorded the deed. He handed me my check and he handed the buyers their keys. I said, I like this attorney. You know, we didn't have to go and come back, and it was nice. Does that happen every time with him? I don't know. But for us, at least he was able to. The man went and got us a bottle of water. I mean, you know, they took care of us and we just chilled out for 10 minutes and then we were done. So I like that. After settlement, there's this period of time after settlement before closing. So after we all leave the attorney's office, the attorney has already done the thorough title search, but usually in that period of settlement, they're going to do one more quick peek just to make sure nothing hit the title from the time they did the thorough title search. Once they have that satisfied, that's when they offer their title opinion and they get title insurance lined up. Remember, we got to send a loan package back to the lender. Upon the lender satisfaction, that's when they release their funds. And then the very last act, document recording, the attorney has to record the seller's payoffs. So if they have a mortgage, we got to record that payoff lien. If they have other outstanding liens. Once all that's done, then and only then can the attorney record the new deed, the buyer's new deed. As soon as they record that new deed, they wait for confirmation from the register of deeds that they've received it, and then they will immediately record the new deed of trust, the new mortgage, because remember, they have an interest in protecting the lender as well. There's usually, the seller may have an IRS requirement. There's a form, it's a 1099-S. We don't need to know that, but the seller needs to report the sale. Usually the attorney will submit that for them, so they don't need to worry about it. Have your sellers just make sure the year that they sell, they share with their accountant. Maybe there's some tax benefits, maybe there's some fees, but just make sure that they are reporting that on that year's taxes. But the IRS has received it. The attorney will, like I said, usually send that in for them. So we made it. Closing. I love closing day. If we, usually we can have settlement and closing on the same day, not unless something happens. And that's what we need to prepare for. Does the internet go down sometimes? Of course it does. Does the register of deeds have a hiccup? Sometimes, of course they do. So while we have settlement this morning, there's no guarantee that it's going to close today. We're shooting for it. We're hoping for it. Fingers crossed. But in the event that something happens, have your people have a plan B just in case. But ideally, we go to settlement this morning. Buyer's got new keys and you got a check, this afternoon. So it should be pretty seamless. I had sellers once, they moved from here back to Myrtle Beach. They moved from Myrtle Beach and got here and decided they weren't happy. So they turned around and went back. And I helped them sell their house here. She called me. It was probably 2 months after closing. She said, Julie, you're never going to believe this. They bought their house at Myrtle Beach and it never got recorded. They were living there for 2 months before somebody discovered that that new deed hadn't been recorded. And she said, could you imagine? I said, oh my gosh, I don't know if it wasn't verified or not, but to me, that just seems like a nightmare waiting to happen. You think about all the things that could have gone wrong. What if the house burned down? Her insurance is going to cover it because they didn't own it. Isn't that something? Think about it. So I like verifying. You and I can go verify the new deed for our clients if we want, or let them know that they can. I would give it a couple weeks, give it time to process. Each county is different, but yeah, tell your buyers, in the next few weeks, go make sure your deed's recorded to make sure it's right. Go make sure it's out there. Comments?
I assume if you had 60 people in this class, it would take longer.
We're just flipping right through. You wouldn't be able to say as much.
Yeah.
That's for sure. All right, the next little section in chapter 14, we're going to talk about Respa and TRID just a little bit, make sure we understand that. We're getting closer to our closing disclosure. So that's the good news. We'll be able to at least start having a conversation about that today. I'm going to have some things I'd like you guys to look at this weekend to get us ready for Monday. So we'll talk about that, of course, before we leave today. So let's talk about Respa and TRID. We're going to better define Respa. We don't get into Respa too much in pre-licensing. So we're going to spend a little bit more time with Respa today. And then we're going to talk about TRID as well. So first off, let's define what the heck TRID is. TRID, we're an industry of acronyms. And let me tell you something, TRID is the acronym of all acronyms. The T in TRID is an acronym for TILA. TILA stands for the Truth in Lending Act. The R in TRID stands for Respa. Respa is an acronym for the Real Estate Settlement Procedures Act. So all TRID is an integration of TILA and Respa. Please understand, TILA's always been around, Respa's always been around. TRID just combined them. TRID put them together. There are cajillion theories about what went wrong in the housing market crash 2008, 2009, 2010. And we're not going to talk about all those theories, but one of the more popular theories was fraudulent lending practices. So one thing that we got from the housing market crash 12 years ago was that we got to tighten up some lender laws. We need to make it easier for the consumer to understand. And part of what TRID did by integrating different disclosures, TILA had a set of form and Respa had a set of forms. And they said, these all look the same. These all look similar. We got people signing pretty much the same thing, and they don't understand why they're signing the same thing twice. So that's when TRID kind of stepped in and said, we're going to make this easier we got to educate the consumer. If they're going to make a 30-year commitment, they should understand what they're committing to. And we're also going to make it easier for them to sign all this paperwork. I mean, you guys have both bought a house. Did you get a little nervous when the attorney plopped down a stack of paperwork like that thick in front of you and said, we got to sign? It's a lot to sign. Do what?
Sign here.
Yeah. That's why I tell my buyers to get your signing hand warmed up, because when we're in there for an hour, that's all they're doing, isn't it? It's just signing. So we wanted to streamline that paperwork just a little bit. When you guys see TILA, I want you to see lending. TILA tells the consumer the cost to obtain the loan. What's it going to cost me to get this money? When you see Respa, I would like you to see settlement. Respa tells the consumer the cost to close. So the two are different, but they work together. One tells us how much is it going to cost me to get the loan. The other one's going to tell me the costs to close. So talking just more specifically about Respa. Respa, was enacted by Congress. Its whole purpose is to protect consumers from abusive lending practices. Guys, Respa has been around since 1974. You don't need to know that. But again, Respa has been around for a while. Respa is nothing new. Anytime the consumer is getting a federally related mortgage loan, Respa is around. Thus, TRID is around. Does this say any loan or all loans? No, it's just specifically, well, first off, mortgage loans. So if you're getting a new loan to buy a car, is Respa around? No, just when you're getting a mortgage loan. And most of what we do is going to be federally related anyway. But if you happen to come across one that's not federally related, then Respa's not going to be involved. Respa's ministered. Dodd-Frank is who stepped up after the housing market crash and said, okay, we got to do something about this. The consumers are confused, and that confusion and some lenders taking advantage of that situation is part of the reason that got us in the housing market crash to begin with. So what Dodd-Frank did was create the Consumer Financial Protection Bureau, CFPB, and that's who gave us TRID. What they do, it's in the name, right? They protect the consumer with their financials, within this particular, their mortgage loan.
Who are Dodd and Frank?
The people that I think it's they're not two people. You know what I'm saying? I think it's
there are two people. They're both were,
okay.
They both were senators.
Gotcha. There you
and
go.
I forgot what Dodd's first name was, but Frank was Barney Frank out of New York. I'm not sure where Dodd was out of, but they were senators.
Thank you. I did not know that. Never thought about that.
and they actually oversee more than the mortgage industry.
Oh, absolutely.
Anything that is financial or federally regulated, Dodd-Frank will provide some oversight or opinion on, and some regulatory end of it for still the consumer investments.
All about protecting the consumer, isn't it? See, and that's what we need. And I think that's why they stepped up after the housing market crash, because you guys weren't around in real estate then. I'm here to tell you it was rough. It was rough. I hope, I know this market we're in right now is going to have some effects and some consequences. I know we're going to see foreclosures and short sales. I pray every night that it's nothing like what we went through in 2008, 2009, and 2010. We're going to see it, but I hope it's not like that again. I wasn't even in sales back then. I was still an admin. And even then, I mean, we had our hours reduced. I mean, I would go in the morning and open the office and just walk up and down the halls and see what agent moved out the night before. I mean, it was rough.
Yeah, I had a lot of high profile clients during that. For example, like Starbucks corporate, I would go into Starbucks headquarters in Seattle, and there'd be people passing me with their boxes coming out as I'm going in.
Yep.
It was tough.
It was tough. And there were, I mean, like I said, there were a lot of agents getting out of the business. I mean, you know, getting out, but it's that trickle down, right? If you have fewer transactions, then you don't need as many home inspectors, you don't need as many appraisers, you don't need as many lenders, you know. So a lot of people, Ronnie, were boxing up and heading out. It wasn't just the real estate agent, you know. So I mean, I picked up some, like I said, we had reduced hours. I picked up some house cleaning gigs just to pay my power bill every month. You know, it was tough. It was tough. So we're going to see some kind of repercussion from this market we're in. I just hope that it's nothing like what we went through before. I sometimes feel like I should have a t-shirt, you know, I survived the housing market crash of, you know, maybe I should, I don't know. So back to Respa, particularly Respas for 1 to 4 family residence lots or mobile homes. Respa applies to lenders whose deposits are insured by the federal government. When it comes to our mortgage loans, the type of loans that we most often deal with, conventional, FHA, VA, those all fall under the Respa guidelines. So we know when we're doing a loan that Respa is going to be involved. If it's a cash buyer, TRID is not around. If it's a cash buyer, the rule is there are no rules, right? The attorney doesn't have to answer to a lender. So the attorney they could use an old HUD statement if they want to. So just keep that in the back of your mind, that if you're ever working with a cash buyer, it's going to look a little bit different than when you're going with a lender, because you don't have all these lender laws and rules.
And commercial has its own set of rules.
That's right. This is residential only. So if you're doing a commercial transaction, TRID is not around. Thank you. So I mean, so many times agents have had closings and then they come back to me in the office and they're just steam's rolling out their ears and they're so upset because I just came back from closing and the attorney did this and they didn't do that and they didn't follow the rules. Who do I call? And I'm like, whoa. Was it a cash buyer? Oh, yeah. And I'm like, then the attorney didn't do anything wrong. There is no TRID. You may sometimes hear Respa referred to as Regulation X. Just FYI. As we said earlier, it doesn't apply for anything more than 4 units. It doesn't apply for commercial, business, or agricultural. So if we look, we're going to break these down. In your book on page 475, what we have is a bulleted list there, 7 different things that Respa does to protect the consumer. So this is kind of the summary on 475. And then as you note on 476, we start giving a little bit more explanation. So you guys may want to make a note. I would focus just more on the summary, have a general idea of what the things that Respa does to protect the consumer. But we're going to go through each of these and make sure we just have a general idea and we understand what Respa does. And the first thing that Respa does to protect the consumer is they're going to offer a borrower credit for the yield spread premium. So first off, let's make sure we understand what a yield spread premium is. If a premium is paid for making a loan with an above market interest rate, then it produces an increased yield to the lender. And it used to be that they put that fee on the borrower and the borrower would have to pay for it. Respa said, that's got to stop. If the borrower gets charged that premium, then that needs to be credited back to them at closing. This should not be an expense borne on the buyer. So if there is this yield spread premium, Respa now requires a borrower credit. And as we say, if the premium is paid, the fee has to be disclosed to the borrower, and they can receive a credit towards their original loan charges. I think we're going to see the common theme of disclosure. We got to disclose to the buyer what these numbers are, what these monies are, and that also applies for this yield spread premium. And then making sure that they get it credited back to them if they do incur that charge. Another thing that Respa does to protect the consumer, loan servicing disclosure. So we need to inform, Respa says the borrower needs to be informed of two things: whether or not the loan can be serviced. If your loan can be serviced, it means whether or not it can be sold or not once you originate it. So whether or not your loan can be serviced. And the second thing that this does is that if the loan is serviced, you should be notified by the lender that sold it and the lender that purchased it. So if your loan is serviced, you should have information, you should have contact from both. Obviously, whoever purchased it, you need to know where to send your payment next month, right? So they're definitely going to want to let you know. But again, whether or not it can be serviced to begin with, some lenders keep their loans in-house and they don't sell them. Some do. So whether or not it can be serviced, and then when it is serviced, we need to notify the consumer, or the lender does. The third thing that Respa does to protect the consumer is they have escrow account restrictions. So they're going to put limit on how much in the borrower's escrow account the lender can collect. We'll see this again when we do our closing disclosure math. We'll figure out how to calculate some of those escrow accounts monies. But with the escrow account, you guys as homeowners know when you make your mortgage payment every month, part of it goes to principal and interest, but part of it also goes to your annual taxes and your annual homeowner's insurance. So when you pay 1/12 of those taxes and 1/12 of those insurance, it goes into an escrow account that the lender has set up on your behalf. And each year when those bills come due, they pay those bills on your behalf. Creating the escrow account at settlement, they put restrictions on that, and then how much they can collect during the term of the loan has restrictions as well. So the couple different limits that we see that the lender can collect, they can only collect 1/12 of annual taxes and homeowners insurance each month. So each year as taxes and insurance go up, maybe go down, but go up, they can recalculate that 1/12, right? But it's still no more than 1/12 of the annual taxes and the annual insurance. The other restriction is how much the lender can collect up front at settlement. So the lender wants to collect like a cushion. As we just said, do taxes go up sometimes? Shake your head yes. Does insurance go up sometimes? Shake your head yes. So if those bills go up, if those charges go up, then the lender still wants this cushion. They want this funny money, if you will, that they can still pay those bills on your behalf. When you pay your loan off, if there's anything left in the escrow account, you'll get it back. So it's not like you're going to lose this money. We just paid our condo off at the end of last year, and I sent my payment in, and probably about 3 weeks later, I got a check in the mail from the mortgage company, and I thought, why are they paying me? Come to find out, it was money that I had left in my escrow. So that was good to know, because they don't get to keep that money. It's not their money. It's just there as a holding place to pay those bills. Again, this is the math that we're going to get to see. We will calculate the number of months. Some of the closing problems that we're getting ready to work are a violation of Respa. So in other words, we're going to see lenders collecting more than 2 months of taxes and insurance. But if we want to get the problem right, we got to do what the problem tells us, right? Just knowing that in Respa, there shouldn't be more than 2 months of taxes and insurance collected at closing to originate the account and have that little bit of cushion. I had a post licensing student earlier this year, and she shared with us that her taxes or insurance, I don't remember which one, was more than what was in escrow. And so the lender actually called her and said, it's like $150 more. We'll still pay this on your behalf. Do you want to send us a check for $150? Or do you want that deducted? Do you want to add like a 12th of that $150 and we can add that onto your mortgage payment? So I thought that was interesting that they actually gave her a choice as opposed to saying, we need money now so we can pay this. They went ahead and paid it and then gave her a choice of how she would like to reimburse them.
Actually, Julie, I get that every year from my bank.
Do you really?
Yeah, I get a new payment book, although mine are drafted. I do the bi-monthly, to help limit my overall impact over the time, which I don't like that, but it does. But yeah, so every time that they will pay it, and then they'll send back an escrow balance statement and show me month to month what they collected, what they paid out. And then they will send me a letter that states, you can make up the gap by sending this payment in.
Nice.
If you don't have it by this date, your new payment effective on, and it gives me the date, will be. So I get a choice. I don't have to respond if I don't want to. And then they adjust on the effective date, they adjust my payment. I've had that happen for the last 15 years.
Yeah.
Well, I'm surprised they haven't
too.
readjusted your monthly so that doesn't happen, your mortgage. Because I
think it's hard to do that with insurance, right? Because it doesn't adjust by that much. It's normally
Sure.
it's like $75 to $80.
Kind of same thing with taxes. You're not going to have that big of an increase, but
And over the years, I've had mine come down a couple times in addition to going up.
So then if you don't change that amount, then you still have, again, that little cushion. And
the monthly payment would come down instead of
right.
going up.
Right.
Yeah,
Right.
And having them put it in there, I'm not paying interest on that escrow money. So it's not like I'm paying because I do that. I'm paying more over the life of the loan. It's because they're just more earmarking it for that purpose.
Exactly.
Yeah, you're not losing any of your equity.
Exactly. Yeah.
So
and when if you win the lottery tonight and you pay your mortgage off tomorrow, they'll send you that escrow, you'll have that credit back to you. So, or, in my case, they sent me a check. So it's just a holding ground. I think some people get upset, the lenders taking more money. They're not taking your money. They're just holding on to your money so that we can get these bills paid. The lender doesn't want the county to foreclose because you didn't pay this year's taxes. So they're protecting their interest.
I'm noticing now that a lot of banks, lenders will not give the option of not securing an escrow account because the risk of lien, and then that affects the lender should they have to foreclose. So many of them are requiring it now. I haven't seen an option presented to me without escrow. I mean, I don't think I've ever had one now.
Every once in a long time, I hear somebody say, my lender doesn't escrow. And I just think, that's got to be, I've heard that like 2 or 3 times in the last 20 years, so I think that having the escrow is definitely more the norm. As you just said, the lender's protecting their interest. I mean, what if I don't pay the taxes and the county forecloses on me? The county's not going to care about selling the property in order to pay the lender back. The county's just going to care about sending the property to get their money. What if I drop my homeowner's insurance, don't pay the bill and the house burns down? It's really easy for me to walk away, right? Now the lender's stuck with. So absolutely to protect their interest. Just be aware, as my husband and I learned in this year, since we've paid the condo off, the letter that we got from the county no longer said your taxes have been paid. This year, that letter is going to say, you owe us, X amount. And same thing with the condo. I had to fight with my insurance company because the annual homeowners insurance was due in like June. And they said, well, we're going to take it from your mortgage. And I said, but it's paid off. I mean, I couldn't explain it to them that mortgage no longer exists. Finally, they got what I was saying. And I was able to send them, send in money for my annual homeowners insurance. But it was like it was a bit of an ordeal. I'm not gonna lie. And I'm like,
Well-
y'all want my money or not? You
Well,
know?
well, many times insurance companies won't change that process unless they've received a lien release from the lender stating that they don't have to show as
Don't
first
have it.
lien.
Then I guess they never sent it. But yeah, I was like, please take my check, please. You know,
Well, yeah.
they took it. I'm covered, but like I said, it was a process. So
Um,
all right, let's take a break. We come back, we talk more about Respa and what Respa does for consumers. All right. Just as an FYI, not that I expect to have any problems, it looks like I got maybe a little storm kind of blowing up. You know, sometimes these summer storms can go one way or another. So what happens if I lose power? It happens sometimes. I'm on a battery backup and I got my mobile hotspot ready to go. So should I lose power, I have learned if I disappear from the Zoom call, you guys don't go anywhere. So if I just disappear, y'all just sit tight. I will get back to you just as soon as I can and we'll pick back up. Hopefully we won't, nothing will happen, but like you said, it's July and you never know sometimes how these storms can turn out, you know?
I know, that's why I was a minute late because I had to go back out and tell my son to keep an eye on the weather because the dogs are outside in another pen. And I said, you need to pay attention because it looks like it might be coming up a bad storm and we're gonna have to bring them in. So I had to go back out and tell him.
Congrats.
So I'm sorry about that, but yeah, I'm watching it from here and it got dark all of a sudden, so.
It did. I looked outside and I was like, wow, there's no sun and it's that wind's whipping around. So I'm right here at I-85. And I think there's something to be said about the energy for the highway, you know, that can kind of, because if you watch a storm, it kind of travels up 85. And so I think it might be coming my way. But either way, as long as we're safe. The worst thing that ever happened to me on Zoom was the day we had the storm come through when we were given the end of class pre-licensing exam. But you know what? We got through it. We got through it. So we will get through it again. But yeah, just hang tight. I'll get back to you as soon as I can once I get my battery back up to kick in. So let's get back. We're talking about the things that Respa does to protect the consumer. So put escrow account restrictions. The other thing, or another thing, I should say, that Respa does to protect the consumer, and this is the one that affected us personally. We can no longer give or receive kickbacks or referral fees for recommending settlement service providers. You and I are settlement service providers. The lender, the home inspector, the surveyor, the attorney, the pest inspector, everybody involved is going to be considered a settlement service provider. And it used to be that, you know, maybe we had a home inspector that would say, for every buyer you send me, I'll give you a $25 Target gift card. Well, gee, that's nice, isn't it? But why was I probably sending that buyer to that home inspector? Was I sending them to the home inspector because they did a really good job and were thorough and they had a good report? Maybe, maybe not. But bottom line, what did I care about? I wanted my $25 Target gift card, right? There was, I think it was a lender. There was a lender that used to say, well, you know, send us your buyer. For every buyer's loan that we close, we'll put your name in a hat. And at the end of the year, we're going to do a drawing. And the winner gets an all expenses paid free cruise. Heck yeah. Why am I sending my buyer to this lender? Because I want to go on a cruise. So Respa said, yeah, that may not be what's in the best interest of the consumer. So they put a halt to all of that. Remember, this is a Respa rule. If it's a cash buyer, can I receive a gift card from the home inspector? Absolutely, because Respa is not around. Property management can receive referral fees and kickbacks because Respa is not around, because the loan's not around. The thing about this that Respa says is anything of value. I can't get $1 or a donut for recommending a settlement service provider. Now, you guys will learn once you start hanging out in your offices, and now that we're, you know, more post-pandemic, you're going to have people come into your office with like a box of donuts, you know, and they may come in with a box of donuts and a stack of business cards and say, we're going to leave these here in the kitchen. You guys help yourself. We look forward to working with you. What they can't do is walk in the door with a box of donuts and say, this is for you, you, and you, because you sent me business last month. right? So they can give what they do for one, they have to do for all. And they can provide all of us a box of donuts, but they can't just thank you with a donut for sending them business.
Does that apply to mortgage brokers who aren't directly making loans?
It should. You hear my hesitation.
Because they're working with a pool of lenders, you know, based on rates.
Because they're working directly with the lender. So I'm not sure if that would, because they wouldn't be a settlement. The lender is the settlement service provider, you know, so the lender shouldn't be receiving, and that's where payment or receipt. Home warranty companies have figured out a loophole, just by the by. I think the best I've understood, the way that they have figured out this loophole is technically they're not providing a service for settlement. Their service is,
if they're not now,
post.
I see that coming back because they're also searching the market for the best rates based on, and they may have multiple lenders coming in similar. They're making a choice as a broker for that too.
Yep.
So
Yep.
I don't know if they're not now. I can see that coming back.
Agree.
That's going to change.
And they need to be careful. They just need to be careful, you know. We had a home warranty company a couple months ago offer to bring us lunch. They want, of course, if they bring you lunch, they got to, you know, do their spiel, which is fine. So they brought us lunch and we were sitting in there eating and having lunch and listening to their spiel. And while we were sitting there, a rep from another home warranty company came in with a box of pastries. And we were like, oh, it's awkward. Oh, it's so awkward. So we got hooked up that day. Home warranty rep number 2 didn't get to talk. As a matter of fact, I don't think he could have left faster once he realized what was going on. But they're starting to come back to the office. And again, if they do it for all, that's okay. What they can't do is just select agents because I sent you business.
Mm-hmm.
When it comes to this, one thing that Respa didn't change, they do still allow agent to agent referral fees because I'm recommending services and I'm collecting a referral fee. But this is one thing that was not affected. So agent to agent referral fees are still allowed, not considered a kickback. And then they do require now disclosure of affiliated business arrangements. So what we mean by this, there's this idea of like one-stop shopping. You can get a real estate agent, a lender, and an attorney under one roof, right? You can go to one service. Well, if you work for a firm that has a lender and or an attorney under your roof, I mean, we can absolutely say, hey, we got an in-house attorney. Do you want to use them? But keep in mind, we cannot make a buyer use our in-house attorney. We can't make a buyer use our in-house lender. And if they do use our in-house services, then we need to disclose if there's any business arrangement. So if there's some kind of, you know, break on rent, if you use my in-house lender or whatever, then we just need to disclose that. I used to work for a firm that had an in-house title insurance company. And we had a disclosure form that buyers had to sign off on, acknowledging that we were, you know, we were under the same roof. We had some kind of business arrangement. Whenever we're recommending settlement service providers, never ever look at your buyer and say, this is the attorney we're using, this is the home inspector we're using, we need to give our buyers choices. So we need to be saying something like, here's the list of 2 or 3 lenders I've used in the past. I recommend you talk to them. Here's a list of, you know, 2 home inspectors that I've used. If you don't know any home inspectors yet, then you may want to check with your firm. They may have a preferred vendor list. So then you could say, here's a list of a couple home inspectors that, you know, that my firm has used. Don't just go to Google searching for home inspectors. They can do that. So part of what we have is a service to help get them good service. And that a lot of times just comes from previous experience. I think we mentioned the other day, even if I say, here's a list of 3 lenders, does that mean the buyer has to use one of those 3 lenders? Yeah, they can use whoever they want to, right? So if they say, well, thanks for this list, but I'm going to use who I want to, that's fine. It's their lender, it's their choice. It's their home inspection. It's their choice who they use. Yeah.
I had a question about that affiliations as it relates to property management firms. So if you're working with someone and you're working to help them establish a lease with a property management company, say you have a buyer, but they decide to lease and they're gonna let you find them a rental. But then, so my question is, when their lease is up, I'm finding some of these property management companies have their own affiliations with cleaning companies, their own electricians. Electricians I almost can understand because that could lead to other ramifications.
Mhm.
But if you're renting out, I've seen a few friends of mine who have been in that position where they've said you must use this cleaning company at the end of your move out, or you will be charged $250. They didn't get a choice. It's
Wow.
one or the other. Now, I wrote a letter back and pushed back on one of them and they let it go. I don't think that most people know that they have to give you a choice. They can't if they're affiliated. But yeah, they try to require that and keep it all in the house, and it didn't cost $250 to get a place clean.
To get it cleaned. And that might be a violation somewhere else, but not under Respa, because we're not getting a loan, right? Because if you're renting an apartment, you're not getting loans, so Respa's not around. So the property manager doesn't have the same Respa controls that the sales agent does, that you and I do. So there may be other regulations that they're, but as far as Respa is concerned, Respa is not around because they're not getting a loan for that transaction. Now, I agree with you. That's kind of poor on the property manager to say, but that's their arrangement. That's their relationship. So, but yeah,
and I'm sure they're being compensated for that.
Oh, absolutely. They're getting some kind of nice kickback. Yep. Maybe even about $250. So one way or another, they're going to get that $250. If they don't get it from the cleaning crew, then they're going to get it from you for not using that cleaning crew, So, and I think that's the thing is, I mean, should everybody have choices? Of course, but it's different once you get out of the sales realm of it, for sure. Another thing that Respa does to protect the consumer, they have the special information booklet for borrowers. So we're going to talk about loan application in just a second, but within 3 days of loan application, the lender should be sending the borrower this booklet, your home loan toolkit. It kind of encourages them about shopping for houses, shopping around for settlement service providers. The process. Again, my husband and I bought this house almost 2 years ago, and it was interesting for me to go through it as a buyer, right? To see that end of the process. And once we had our loan application, we did receive, our lender used like a secure email where they would send me an email and say, we put new documents in, log into your account to view it. That allows them to see that I open it, I viewed it, I saw it, date, time stamp and everything. And we did get this booklet in like a PDF format. I didn't get, this actual booklet, but we did get this in a PDF format. So that was good for me to see that this is like real, that it really does happen. But just this booklet encouraging buyers to shop around for settlement service providers. Another thing that Respa does to protect the consumers, also within 3 days of loan application, not only do we have the booklet, but within 3 days of loan application, the consumer is supposed to have the loan estimate or the good faith estimate, depends on who you're talking up to. Loan application is actually defined on page 479, if we want to look at that real quick. Loan application is defined, the lender receives 6 pieces of information from the borrower. And you can see there, there's 6 bullet points about almost halfway down. 3 pieces are about the people, 3 pieces are about the property. So once we have those 6 pieces, then we have what's considered loan application. And that's what triggers the 3 days to send the loan estimate and the booklet. So we can only get so far through the loan approval process until we have a contract, right? We can get the people going, we can get the people moved, but we can't actually get going on the loan application until we have an address of a property, value, and the loan amount. The last thing that we're going to talk about that Respa does to protect the consumer is issuing a closing disclosure. The HUD-1 settlement statement is what we did use. The HUD-1 settlement statement might be what the attorney still uses if it's a cash buyer, maybe in commercial transactions, I'm not sure. But now in residential, now we have closing disclosures, and we actually got two, one for the buyer and one for the seller. We'll talk a little bit more about those in just a bit. So Respa's regulations, I think it's important that we keep in mind that TRID is a lender law, but because we work so closely with the lenders, and we're in on this, no kickbacks or referral fees, right? So we do have a piece in this as well. There's some pretty, I'd call them hefty penalties for violating Respa. You're looking at criminal fines of up to $10,000 per violation. How's that $25 Target gift card looking now, knowing you could face a $10,000 fine by accepting it? It's not worth it. You could get to go to prison for up to a year. They could put an injunction on you. An injunction is a legal stop. So if the real estate commission or the courts put an injunction on you, you're not working during this in real estate during this investigation. There could be civil lawsuits and monetary damages 3 times. Plus, you would get to pay your court fees, attorney's fees, and probably that of the other party as well. And please don't think that the North Carolina Real Estate Commission won't get involved. Absolutely would be a violation. Violating the improper, fraudulent, or dishonest dealing. So again, I got to ask you, is that $25 gift card worth it? I don't think so. I could go on a cruise for $10,000. I'd rather pay that to Carnival than, criminal fines or whatever. So comments or questions on that? We are going to watch a little video. This is a video that kind of explains TRID, how we got TRID today, where we are.
October 3rd, 2015. TRID becomes mandatory and changes the real estate closing process as we know it. So what should buyers, also known as borrowers, that fall within TRID expect when buying a home? All borrowers that fall within TRID guidelines will receive the LE, the loan estimate. This form outlines the estimation of fees for closing. Lenders are required to give accurate fees, and this form must be provided to borrowers within 3 days of applying for a loan. For closing, borrowers receive the CD, the closing disclosure. The closing disclosure must be provided to borrowers at least 3 business days before closing. And yes, Saturdays are considered business days. Failure to deliver the CD at least 3 business days before closing will result in a delay of closing. So why the new forms? Pre-TRID, buyers would meet with a lender to apply for a loan. The lender would ask, "So if you had your dream job, how much would you make?" Or, "Mr. and Mrs. Borrower, just breathe into this mirror for me. Have you seen the movie The Big Short?" Now, to be fair, not all lenders were doing shady deals. There were and still are plenty of great mortgage providers to work with. But that is a conversation for another day. Out of the 2008 mortgage crisis, the President signed the Dodd-Frank Act into federal law on July 21st, 2010. And on July 21st, 2011, the CFPB was formed, the Consumer Financial Protection Bureau. The CFPB is an independent agency of the United States government responsible for consumer protection in the financial sector. The Bureau is charged with enforcing the laws within the mortgage industry. Consumers who feel they have been mistreated can voice their complaints directly to the CFPB. The CFPB can fine violators up to $1 million per day per violation. So we have talked about the forms and the how and why the CFPB was created. But what does the closing process look like for borrowers that fall under TRID? Most of the changes have to do with mortgage lenders. When borrowers work with lenders, there are a lot of forms to sign. No, more forms than that. Getting close? There we go. How about with attorneys at closing? You see, previously the buyers and the sellers would meet at the attorney's office at the same time to sign documents. Now, while the sellers sign documents, the buyers can still be in the room, but when the borrowers sign, the sellers can't be in the room. The reason is because the seller cannot see the private loan information on the buyer's closing disclosure. Remember, the CFPB is called the Consumer Financial Protection Bureau. The buyer is the consumer, so most of the rules are aimed at protecting the buyer. You might be thinking, well, are all buyers subject to TRID? Great question. The answer is no. Here are the types of borrowers that are not subject to TRID. Borrowers seeking a home equity line of credit, also known as HELOCs, those looking to obtain a reverse mortgage, those obtaining a mortgage secured by a mobile home or dwelling not attached to land, borrowers who are seeking a no-interest second mortgage made for down payment assistance, energy efficiency, or foreclosure avoidance, and the last but certainly not the least, those getting a loan from a creditor who makes 5 or fewer mortgages in a single year. All of these types of borrowers, as well as cash buyers, will receive the HUD-1 settlement statement at closing rather than the closing disclosure. So what kind of buyers does TRID apply to? All closed-end consumer mortgage loans secured by real property purchased primarily for personal, family, or household purposes, including construction loans, vacant land loans, 25 acres or more loans, or single-family residence loans. There you have it, TRID, the Truth in Lending Act, Real Estate Settlement Procedure Act, Integrated Disclosure Rule. Thanks for watching. For more great free resources.
All right, so I think that's a cute little video, cute little introduction to TRID for us. A couple things in the video I saw that I just like to make sure. The lending process itself has tightened up since the housing market crash. It used to be really easy to get a home loan. I mean, really easy to get a home loan. Sometimes there were some lenders, probably not the best practice, but there were lenders that would just ask you, how much do you make? What's your debt? And based on what you told them, they would issue a loan. We see where that could go really, really south, really fast. The other thing is, I think that one of the biggest changes with TRID was that now buyers and sellers aren't in the same room together. You know, it used to be they all sat down at the attorney's office, but now, like they said, the buyer can be with the seller when they sign, but the seller can't be with the buyer. Since TRID is protecting the consumer, the buyer is considered the consumer in this transaction because they are the one that's originating the loan. They are the one that's getting the new loan. The seller is going to be protected as the borrower with their loan. Does that make sense? So in this transaction, it's not about protecting the seller. It is about protecting the buyer because they are the consumer in this transaction. So as they said, TRID was born on October 3rd, 2015, still so very new, if you think about it. Now the documents that are required by TRID are the loan estimate within 3 days of loan application and the closing disclosure within 3 days prior to settlement. We'll talk a little bit more about those days in just a second. And TRID is a lender responsibility. TRID is a lender law. Okay, it's the lender's requirement to abide by TRID. Why do we care about it then? Because we're the ones working with the buyers, the borrowers, we're the front line. We have a duty. We always got to be paying attention for flags. And when we hear our buyers talking about something with their lender, we need to be paying attention to make sure that that lender's in compliance. I had buyers a couple of years ago, and they were doing a short sale. And you know, those things are known for taking forever, right? They say on average, you can expect 6 months from contract to closing. Y'all, it took us 11 and a half months. And before the end of the transaction, the listing agent was actually calling the CFPB and reporting the lender, because even the listing agent felt that they were dragging this on. Now, I mean, nothing happened. We didn't get anywhere, but the CFPB is out to protect the consumer. So if you ever feel that your buyer or borrower is not protected, then encourage them to reach out to CFBP and report it. Let them investigate it. So let's talk about this loan estimate. The loan estimate was formerly called the good faith estimate. You still may have some old school people that still refer to it as the good faith estimate, but we're referring to the same thing. Some information that they will give on the loan estimate includes the loan amount, the interest rate. Is there going to be a prepayment penalty? Is there going to be a balloon payment? What is the estimated PITI, principal and interest, taxes, and insurance? What's the estimated borrower settlement charges? What's the estimated cash to close? The thing I want us all to see when we talk about the loan estimate is that this is an estimate. We're only 3 days from loan application. We don't know everything yet, but within 3 days of loan application, we're sending the borrower an estimate of their cash to close, an estimate of their payments and their loan commitment. 3 days within loan application. That still just blows my mind, because this wasn't always the case. Guys, sometimes prior to TRID, there were circumstances where the buyer may not know what their monthly PITI was going to be until they were sitting at the settlement table. Could you imagine a 30-year commitment and you don't know what your monthly payment's going to be? I mean, that was probably more of the rare than the norm, but still there were circumstances where that happened. I heard stories from agents that we didn't know the buyer's cash to close until we got to the attorney's office. And after we left settlement, the agent was following the buyer to the bank to get their certified check. I mean, they were cutting it sometimes that close to the wire. So that's one big thing that TRID said, is that we got to let the consumer know their numbers as early as we can, even if it's just an estimate. Because it's an estimate, there could be changes from the estimate to the final closing disclosure. And how much, what is allowed to change and how much depends on the charge that we're talking about. There are some permissible variations. TRID calls them permissible variations. And basically what these permissible variations say is any cost that is less than expected, less than was what on the loan estimate, is okay. That's good news, right? If you think you got to bring 20,000 to closing and then you find out you only have to bring 18,000, that's good news. If you think you got to bring 20 and then you find out that you have to bring 25, that's a problem. And that's not a permissible variation. So anything less than expected, TRID says that's okay. That's good. Things that can't have any variation whatsoever. Fees paid to the lender. Once the lender tells the borrower, I'm going to charge you, it just started pouring. Once the lender tells the borrower, I'm going to charge you a 1% loan origination fee, that is the only fee that they can charge. Okay, they cannot change that once it's quoted. Now, let's keep into consideration. If it's 1% of the sales price, the loan origination fee is 1% of the sales price. If the sales price change, then the fee is going to change, right? It's a percentage of the sales price. What can't change is that percentage. So if we renegotiate the purchase price, then the fee may change, but what they're charging isn't going to change. We also can't have a variation with the lender required services for which the borrower may not shop. An example of this is the appraiser. The borrower doesn't get to choose who does the appraisal. Why? Because it's not the borrower's appraisal. It's the lender's appraisal. They're the ones that want the appraisal done. It's just that the buyer gets to pay for it. But they can't have, when they're told the appraisal is going to cost you X amount, there cannot be a change. We can't have variation. And then the last thing that we can't have any variation, other states may have something called a transfer tax. We don't do transfer taxes here in North Carolina. But if another state has a transfer tax, whatever the borrower is quoted as having that transfer tax is, that is what it is. Again, no variations, cannot change. There are some variations that we're allowed to have a 10% change, up or down, 10%. Recording fees. And then charges to the third party that the borrower is allowed to shop for services. So for example, the home inspection. We're going to give you an estimate of the home inspection. We may not know just yet. We haven't had time to order the home inspection yet. We may not know how much they're going to charge, right? So we got to have some variations there. When it comes to these charges, it's been my experience that lenders put in very high amounts. And then again, usually have those the actual less than the estimate. So they're kind of preparing them for the worst case scenario. But again, all home inspectors are different. They all have different fees, different charges. So until we know what home inspector we're going to use and we get that ordered, then we need to put in an estimate. We need to allow for the borrower to understand part of all their big picture costs. So let's take just a second. Let's look in our book. If you will, let's look ahead and let's look at page 494. I got to turn a light on. It just got so dark here. So on page 494, we have a sample loan estimate. And you can see at the top there, we got information. There's the applicant, the property, the price, and then you have the loan terms. We can see it's a conventional loan. Tells us about the rate lock. And then we come down a little bit and we see the loan terms. There's our loan amount. Can this amount increase after closing? No. There's our interest rate. There's our monthly principal and interest. Does this loan have a prepayment penalty? Yes or no? Will this loan have a balloon payment? Yes or no? It's pretty clear there, isn't it? It's really simple. It breaks it down. It lets the borrower look at that and see what they're getting ready, what that loan commitment is going to be. Come down a little bit further. There's our projected payment, our estimated mortgage insurance, estimated principal and interest, estimated escrow. So here we are within 3 days of loan application, and there's your estimated total monthly payment. You know, you're looking at $1,050 for your PITI. Come down a little bit further, there's your costs at closing, there's your estimated closing costs. And then there's your estimated cash to close. Again, 3 days within loan application, the borrower knows that they need to bring $16,054 to settlement. Over on page 495, that information tells us how we get to the $16,054. So it looks at the loan costs, what the lender's going to charge, the origination charges, discount points, services they cannot shop for, such as the appraisal, credit report, services they can shop for, pest inspection, survey. Other costs in the second column, there's our taxes and government fees, prepaids, initial escrow. And then it calculates that cash to close. So again, it takes the estimated cash to close of $16,054 on page 494, and it breaks down how we got to that number. So they're not just throwing a number at the consumer. They're actually telling the consumer, hey, this is how we calculated that. The rest of it finishes up on page 496. We'll look at our sample closing disclosure in just a second, but just in a little bit more information. So this gives us an idea about what our buyers are going to see, that loan estimate, and we can have conversations with them. We can say, you can expect to get this email from your lender within 3 days of loan application that gives you this loan estimate. Look at it. Make sure you're good with the numbers. Make sure you don't have any questions. Take some time. When was the last time when did you guys buy your house? How long has it been?
We just did a refinance with a cash payout because of my divorce, and we went through
Okay.
this last year. But again, I had my license in 2006, so I was used to the old HUD settlement.
Yeah.
And so for me, it was very different to look at. It was kind of interesting, but it was helpful to me though. It definitely was.
Absolutely. Absolutely. Because you probably remember whenever you bought, you may not have been provided with all this information at upfront.
Mm-mm. I will say though, they sent a title notary out to the house. We closed here at the house with a notary. That was using an attorney out of Charlotte. So it ultimately
Okay.
went there. They were just overseeing all the signatures here.
Gotcha.
But the day of closing, when the notary was coming out to the house at 5:30, I still had not received my final closing document as of that day. And my lender, who I worked for the bank, but not in the mortgage group, but I had done several loans with her, over the years. She was on vacation.
Oh.
And so now I'm trying to get a hold of someone in the underwriting group, to look at this. I finally got it at 4:00, and it was completely wrong.
Oh.
Completely wrong. They had all the money, the equity money that was coming back. They showed 100% of it going to my ex. And I'm like, hell no.
No.
And, but then they also had our our down payment. I was reinvesting my portion of equity back into the new loan, and they were showing that more than what it was supposed to be. So, I'm not kidding you. I had to do an Excel document, and I had to lay the numbers out.
Oh my gosh.
And then I had to send it to my ex because he was also, a recipient of the seller's disclosure. What to expect. I'm like, this is wrong. He's like, I'm okay with it. I bet you are. But no. And then he had to agree with my numbers. Then I had to send it over, and the notary showed up here, and the document was encrypted, and she had the old, and we couldn't print the new document.
Wow.
And so we had to pull it up on the computer and look at it. She proceeded with everything else and documented it. And then we finally got my person back. I got the document where we could print it, and the notary had to come back out a week later just for that one piece because the bank couldn't. So that when I watched this and I knew what I would do, that ticks me off.
Yeah. It sounds like that would have been a good case for the CFPB, doesn't it? I mean, really, because
if it wasn't that my friend was the lender,
yeah,
I wouldn't have thrown, because she had done all she could do. All this was coming from underwriting, this piece of it. If it hadn't been for that, I would have, and I wasn't going to throw her in the bus because she actually does a good job. But yeah, and this is a very large bank in the Southeast.
See, could you imagine if you didn't know what you knew? I mean, if you were just a consumer that didn't know, could you imagine? You wouldn't know. You wouldn't know to check this and look at it, and
it went all the way to the top. There, my mortgage package, for whatever reason, was flagged by the corporation. And they called me, and they got quite the earful of my entire experience. So it was not a good experience. And I straight up told them, this was the bank I worked for.
Right.
for 18 years. And
So,
I told them, I said, I will promise you one thing, until you guys get all your crap and I hear better, I will never recommend someone get a mortgage with you,
right.
because you
So
guys.
when you're telling your buyer, here's a list of 3 lenders, that's not gonna be on that list. That's what I'm hearing. That's
No,
horrible.
I'll give them others, but I will not, because I could not in good conscience hope that a buyer of mine would have to go through what I went through.
Especially if, like, think about a young first-time home buyer, like I said, that doesn't know what you know, you know? I mean, I'm so sorry. That's a terrible story.
Yeah, it was
And,
awful. I'm gonna tell you, it was, so my fiance is a physician, and his financials, because they could see he has private practice. And so they consider him self-employed. And so the amount of documentation as accountants, they kept going back, and he kept having to go back to these is a big accounting firm in Greensboro. He had to keep going back and asking them to resend things, even though we got copied that it was sent, but they wouldn't take it from us. So it was embarrassing for him,
Yeah.
from a professional perspective, but also we were loading documents into their portal and they couldn't find it, even though we were loading it
oh my
from,
gosh.
from a link they gave us to load, and then they couldn't find it. And then internally they were like, well, the underwriter picked it up and they classified it wrong in the portal, therefore we couldn't find it. Well, what am I supposed to do about that?
Right.
So we were jumping. So I'm just saying this because if it had been another buyer, like, I was so frustrated over the entire thing. And I will tell you also, I got close to closing. The girl who was doing not the back end underwriting, but the front end underwriting, she kept coming back to us, asking us for things that we knew we had provided in the very beginning of the loan. And then I got something from her on a Friday that said, we are so close to signing off, we need these 2 things, and we are ready to sign off on underwriting. I'm like, okay, that's easy to get. So I got her those 2 things that day. I get a call on Monday afternoon from her manager, an email from her manager saying, we're still missing these 8 things before we can sign off on the loan. And that's when I picked up the phone and I blasted them. I said, how can I have 2 things you need on Friday and 8 things on Monday?
Right.
Who is watching this? You're the manager.
Nobody.
Oh my God. I am not kidding you.
Wow.
There's no way in HE double hockey sticks that I would send anyone at this moment, because this particular bank just went through a major merger.
Yeah.
So,
wow.
don't do it.
They got to work some kinks out. It seems like that's crazy. You said this was just last year?
September.
September.
Oh, it's funny. Since then, we have received reimbursements from the trust attorney for 3 different things that they overestimated so far. And it closed. That, I mean, we got almost a $3,000 check back.
Nice. Well, there's that.
It was it was a nice thing, but why is it something $3,000 off?
Right.
I mean, just that type of stuff was like,
that's crazy.
I'm telling you, what they did, I learned from my friend, is when the 2 banks merged, they adopted the other bank's policies and procedures for mortgages, which is the same policies and procedures that 12 years ago almost bankrupted that bank.
So
I'm like,
kind of proven. Yeah.
What are y'all doing?
Yeah. Yeah.
I can't. I mean, if I ever have buyer, I mean, that.
Yeah.
I
can't blame you there.
So just be aware. That was my personal experience. And we started.
And that sucks. Yeah.
We started the mortgage process for our refi in May. And we closed on September 29th.
September, 4 months.
And on September 29th, the week of that closing week, they started coming back asking for other things. And I had a separation agreement that basically said we had to close by this date. If I didn't close by that date, my ex my option to buy was going to him.
Wow.
And so.
So
we're
there was a
sitting-
timeline here. I mean, there was, yeah,
Yes.
that's a mess.
we're-
I'm
we're-
so
I'll tell you,
crazy.
we were sitting there and they started asking for more things, and my person that I trust finally got involved and said, you guys do not understand, if we do not close this loan on the 29th, a couple things are gonna happen. And she laid that out and she said, second of all, we start the underwriting process all over.
Right. Oh, gosh.
She said, which means all new bank statements, all new financials, all new mortgage statements. She goes, because they're only good every 30 days.
Sure.
And I'm like, what? I was ready to like burn the house down.
I bet. How
Okay.
stressful.
It was. So I'm just telling you, there are things. And so for me personally, I know that's a long story, but this
Right.
document,
Is
I appreciated it because it helped me, but
yeah.
I didn't get it timely.
Right.
Didn't.
Wow.
Yeah.
That's
They have closing.
that's like amateur stuff almost, you know. You're right, it kind of seems like it was their first this is our first refi. Let's see how we do with it. Ronnie, did you have a better?
Compared to Deborah, I have nothing. I have nothing.
It was awful.
That is horrible. Well, thank you for sharing that.
And I have probably
A
done
learning experience too, you
Yes.
know.
And I'm not new at this either. I mean, I bought and sold 3 houses, and I've probably refied at least over 20 years, 6, 7 times. I never ever. I mean, it was wow.
Thank
So,
God that's behind you, right?
So Deborah, you're highly recommending Truist.
No, and I didn't say. I didn't say. You come back
Oh
on
my
your own.
goodness. There are everybody has a bad day. I always like to remind
Yeah.
myself that at first. Everybody has a bad day. You know, sometimes you get a bad transaction, a bad experience, but yes, there are others out there that you can recommend your buyers and hope that they don't have a bad day or a bad experience. So
Yeah.
wow.
But let me ask this, Julie, if that were your buyer, I'm just curious because I'm trying to figure out as a consultant in real estate to your buyer. I mean, how do you deal with that? I mean, to what length do you as a broker support that, and what do you do?
I would probably have encouraged them to go on to the CFPB because that's you know, their job is to protect the consumer, right? And to me, as you, the consumer, you weren't handled properly, let's just say. So if I was the agent in that situation and my buyers were going through this, and I don't know that I would go to the CFPB on their behalf, you know what I'm saying? Because they're the ones that are actually, but they're the consumer. So I think they would have a bigger voice with the CFPB than I would. But I would absolutely, you know, get them to the website, get them a phone number, you know, something, get them, and highly recommend, yeah, that they report that at least. And can the CFPB and do anything? I don't know, but that's part of what they're supposed to advocate is that consumer protection, you know.
Now, is there any out from the bank considering this was a refi compared to a new origination loan?
Well, it was with the cash out because we had to change the title and everything. We had to change the
So
deed,
it was,
everything.
All right, but if it was just a straight up refi, would that be looked at through a different set of eyes?
possibly, I don't know. I don't know the answer to that. If that would be a different, I guess, kind of department, what you're asking there. I'm not sure, but there's, you know, different processes involved with a refi versus an origination. So I don't know if that would be handled differently or not, but I mean, bottom line is that's not how we protect the consumer. So
No.
I think somebody would need to know. So Deborah, thank you for sharing that nightmare. And I'm glad you're out of that. And
I'm
I bet
thinking
you'll
about
think
I'm
twice the
thinking about
next
sending you
time
a box of cookies.
That's crazy. All right, let's go ahead and take our break. Let's take 10. We come back, we'll keep going. I just came back and saw Ronnie's note. Deborah, did you see that? That was awfully nice of you, Ronnie, to have that cream cookie in her honor.
We're a team here.
That's funny. Okay, so the loan estimate, we looked at a sample. Again, understanding it's an estimate, so there may be variations. Some things can change, some things can't, some things can have a 10% variation. What's our responsibility with this? Where do we fall into this? Well, this is where it comes back to us having a general knowledge about TRID. We have to have a general understanding of how TRID works, what the consumer to expect. And to Deborah's point, know when our buyers aren't being treated properly by the lender, and helping them get the resources, get to where they need, where they can get help. So that's where that Consumer Financial Protection Bureau comes in. And with anything, we're going to encourage our buyers to shop lenders. And I know that says shop lenders. We're going to encourage our buyers to shop everything. Closing attorneys, home inspectors. Again, we're never going to look at them and say, this is the attorney we're using. To be honest, most buyers don't know closing attorneys, and that's why they're looking at us. And when I recommend a closing attorney or a lender or a home inspector, I'm not validating their work. I'm not saying that they're going to do a good job. I'm just saying I've had a good experience with them in the past. Recommend that you talk to them. Questions about the loan estimate. Then 3 days of loan application. So let's fast forward now. Let's just skip through the whole process and let's get to the end or near the end and talk about the closing disclosure. There are 2 closing disclosures now, one for the borrower and one from the seller. Both contain their money information, how much they're due, how much they have to pay. The borrowers also discloses all transaction-related expenses. Any money that changes hands as a part of this transaction needs to show up on the closing disclosure. Even if that money was paid by or to or from, there we go, a third party. If the money changes hands as a part of this transaction, then we need to have it on the closing disclosure. So let me ask you guys, can mom and dad pay for the home inspection? Yeah, absolutely. But it's going to show up on the settlement statement as paid by third parties. Okay. I had a situation before where the buyer's boyfriend put down the earnest money deposit as a gift. Is that okay for him to do that? Of course, but it had to show up as a gift from the boyfriend on the settlement statement. So any money that changes hands, and again, this is one of these places where you and I, we're the front line. You know, we hear some of these things. We always got to be listening. Let's say your buyer goes under contract and they want to go back out to the house now that we're under contract, and they want to bring some paint samples and they want to bring mom and dad so mom and dad can see it. And you're standing there in the living room with them and you hear mom and dad say, "We're so proud of you. We would like to pay for the home inspection," right? That's the kind of thing that we need to be listening to so we can report that to the lender so the lender can have that and show that money change in hands. As we've said, TRID only applies if a lender's involved, if it's a cash buyer, or if it's a rent or a lease, then TRID isn't going to be around. The consumer in this transaction is the borrower. This is who we care about. This is who TRID cares about protecting in this transaction. And then again, any money, all money that changes hands as a part of this transaction has to be on the closing disclosure. A big part of TRID, other than educating the consumer, a big part of TRID is disclosing. So that's why we need to make sure that all monies are disclosed on that settlement statement. So the closing disclosure, the lender has to deliver the borrower's CD no less than 3 business days prior to settlement. And we're going to talk about what is considered a business day in CD world in just a second. We'll get to that. So the lender, when the lender is delivering the closing disclosure to the borrower, this is one place that you and I cannot be involved. It's not that the lender sends it to you and says, will you forward this on to your borrower? This is communication directly between the lender and the borrower. I mentioned earlier that when we bought the house 2 years ago, our lender had a software program where they could see they had a date and time stamp for every time I logged on, every document that I looked at, right? That was their software that protected themselves. And that's how they could prove when they sent me my closing disclosure, I had to actually log on and access it. And that's how they knew when I saw it, because they allowed me to does that make sense? Access that software to see that closing disclosure. They could see when I logged on. So we have to deliver within 3 business days prior to settlement. And actually 3 business days is the norm. Technically, the rule says it's 3 days if it's delivered personally. So it's 3 days if the lender actually hands it to the borrower and says, here you go, or if they can prove that the borrower has received it. And that's why I think a lot of lenders now kind of use that software that actually shows them who logs on at what time, who views it at what date and time. If it's not personally delivered or it can't be verified, then it's going to be 6 days. We have to deliver the CD 6 days prior to settlement. In all my years since TRID came out, I have never had 6. We've always had 3, because again, I think most of the lenders are using that software that shows when you log on and access it. So what in the CD world, what is considered a business day? Well, Sundays and national holidays don't count. So in the CD world, Saturday is considered a business day. And when we count days, the first day begins the next day, not the day of receipt. So for example, today is Wednesday. If your borrower receives their CD today, we're going to count tomorrow as day 1, Friday is day 2, Saturday is day 3. What we're saying, if your borrower receives the CD today, there's no possible way for us to close before Saturday. And good luck finding a closing attorney that's going to be working on Saturday. So if they receive their CD today, when are we going to close? It'll probably be, it can't be before Monday. If your closing is scheduled for Friday and your borrower doesn't get the CD until today, closing will be delayed. That's just all there is to it. There's nothing you and I can do about it. There's nothing the lender can do about it. There's nothing the attorney can do about it. We have to have those 3 days. When we talk about national holidays, we're talking about the big, just kind of FYI. So let's pretend that Monday is Christmas. So you have Thursday's day 1, Friday's day 2, Saturday's day 3. They're going to be closed on Monday. Now we're not closing until Tuesday, right? So we got to take those into consideration. Again, this is a conversation we can have with our buyers. When we're right at a week away from settlement, we need to look at our buyers and say, you're going to get a very important email from your lender. When you get it, you need to open it. You need to address it, because if they want to sit on that email for a couple of days, they could be delaying closing. They can't say, well, I got it and didn't open it. Let's close on Monday anyway. We got to have 3 days from receipt before we can go to settlement. Y'all mark my words. You will have a closing delayed because of this rule. And there's just absolutely nothing that can be done about it. As we mentioned earlier, the lender is the one that's responsible to comply with TRID. TRID is a lender law. The lender is the one that issues 2 separate CDs. Again, this is not the attorney's show. This is the lender show. The lender is telling the attorney how to do it, how to sign my loan paperwork, how to sign my loan documents, my loan package. And when it comes to the closing disclosure, the delivery is actually to the borrower from the lender. They can't use us as a pass-through. We can stand in place when it comes to communicating offer of acceptance. We cannot stand in place when it comes to receiving this closing disclosure. So usually what happens, 3 days prior to settlement, at least, the lender sends it to the borrower looks it over, signs off on it. A 3-day clock starts. The lender will then get with the attorney or the paralegal and kind of finalize everything, put the finishing touches on everything. Once the paralegal has a final closing disclosure, or the attorney, that's when they send it to you and I to review. So you and I aren't going to get the CD from the lender 3 days prior to settlement. You and I are going to get it from the paralegal the day before, you know, maybe the morning of in some cases. Once we get it from the attorney, that's when we need to review it for accuracy. The buyers don't know the numbers. The buyers don't know what to look for, but you and I do. And that's the math that we're heading towards in this class.
All right, on your slide there, it says lender decides whether to issue separate CDs. So they can actually just do one disclosure for both?
If they really wanted to, they could. I don't think they would.
What
but
happened
they
to that
could.
protecting the consumer thing?
Exactly, which is why they're not, which is why they're keeping them separate. But you know, if it's a lender law, so the lender, what we're saying here is the lender drives the show. The lender's the one that rules it. So could they just put one? Yeah, but they're not going to. They're going to issue two because we're protecting the borrower, right? We're protecting the consumer here.
Unless it's Deborah's cluster that she had
I was
back
thinking
in
maybe
September.
the lender doesn't know what they're doing, or in maybe the case of a refi, you know, that might be a case where you just have one.
I'm looking at it. I mean, I could see why a lender could do a joint closing statement, because I'm looking at it and it doesn't necessarily disclose any terms or confidential data related to the loan itself. There's no
What you do?
interest rate or terms of the loan or anything on this. It's the standard fee layout.
Right. So that may be when they decide just to do one. What about, let's talk about this for a second. What if, let's say you are a dual agent, you represent the seller and the buyer, and the closing disclosures come out, the paralegal sends you the closing disclosures. You now have access to both, right? You have the sellers and the buyer CDs. Are we just going to hit forward and send both to both parties and say, here you go, check this out? Or are we going to take some caution and only send the buyer their CD and the seller their CD? Does that make sense?
Yeah, that would be the prudent thing.
That would be the prudent thing. And I mean, guys, I'm not going to lie. I've had cases before where it's myself and another agent from another firm. We're not dual agency. We're cooperating together on the transaction. And the paralegal has sent one email, one to both of us with both CDs. Don't I have a duty to make sure that the seller only sees the seller and the buyer only sees the buyer? So I think this is another thing for us understanding that how TRID works. And we can help as well, making sure that that information stays separate. So if you do somehow get your hands on the other party's closing disclosure, just make sure you're keeping that separate, making sure that your buyer's only seeing theirs and the seller's seeing theirs. As with the loan estimate, once the closing disclosure comes out, there could be some changes. So we issue the closing disclosure. Again, the lender and the paralegal still got to put their finishing touches on it. You and I got to review it. When the CD comes from the lender to the borrower, it's not a done deal. And so there could be some changes. Not all changes require a new 3-day count. There are only a few changes that will require a new CD, and then we have to have a new 3-day count. if the APR increases by more than 1/8%, the lender will issue a new CD and then start our 3-day count again. If there's a change in the loan product, if for some reason we're switching from FHA to conventional, we're going to issue the lender will issue a new CD and we'll have a new 3-day count. Or the addition of a prepayment penalty. Again, the lender will issue a new CD and we'll have a new 3-day count. Every other change, any other change will not require a new 3-day count. We still got it. The lender will still need to issue new CD. We always got to make sure the buyer has the current CD. But let's say, for example, in practice, a lot of our home inspectors here in the Triad will allow the buyer to pay for the home inspection at settlement. So they'll go ahead and provide the home inspection. They may put a credit card on file just in case, right? But they'll perform the home inspection, release the report, and then allow the buyer to pay for it at settlement. When that happens, the home inspector will send us the invoice. They send it to the buyer as well, but they send it to us. And we need to know to take that invoice and send it to the attorney so they can add it on the settlement statement to make sure that the home inspector gets paid from closing. Everybody with me so far? So let's say you're reviewing the closing disclosure and you don't see the home inspection on there and you go, oh crap, I forgot to send it. It's okay. This is why we're reviewing it. You need to get that fixed. You need to get that sent. That's a change that is not going to cause a new 3-day count. The paralegal will add it, we'll report it to the lender, notify the lender. We'll still get a new CD, but we don't have to have a new 3-day count. We're going to learn how to prorate taxes. So let's say you're looking at checking for accuracy and you notice that taxes are wrong. You call the paralegal and say taxes are wrong. We got to report mistakes without fear of delaying settlement. Everybody good with that? So we always report mistakes. The only thing that's going to cause a new 3-day count is going to be an increase in the APR, a change in the loan product, or the addition of a prepayment penalty. No other change will require a 3-day count.
And none of those three are in our control.
Exactly. Isn't that the truth, Ronnie? This is all on the lender, isn't it? So I tell you that if you make a mistake, it's okay. You got to report it. If you catch a mistake by the paralegal, you have to report it. I think sometimes agents get worried that they're going to offend or bother somebody. Y'all, this isn't your bottom line. This is your buyer's bottom line. This is your seller's bottom line. And we owe it to them to make sure that those numbers are right. Another set of changes could happen after settlement. The only thing I could think of that could happen after settlement is if the address is wrong or the name is misspelled or something. I don't know. But in the rare event that a change occurs post consummation, obviously it's already happened and we don't have a 3-day count. They just make the change and do what they need to do. But I'd like to think that that'd be more of a grammatical thing than anything.
All right, during the contract period, if the seller agrees to repair something and everything's in writing, but the repair is going to take longer than closing, is that notated anywhere in closing, or is that just an outside agreement?
It could be an outside agreement. We'd probably want something in writing. We may have to have the attorney draft something up. I think I told you guys on Monday, we had the seller put some money in the attorney's escrow account. So once that work got done, we could just send the invoice straight to the attorneys and they could pay from that escrow account, and then if there was anything left over, it would obviously go back to the seller. So I think if it comes to that, Ronnie, we can kind of, keep everything on track, if the parties are in agreement, of course, but keep everything on track, closing on track, and just have, my buyers and the sellers all felt comfortable doing this repair after closing because we all knew the money was in the attorney's escrow. Right. So there's.
Well, I was looking at the changes that occur post consummation, and I didn't know if that would fall under that heading.
And it was reflected on the CD that the money had been deposited, right? And then, like I said, once the work was done, the invoice just went straight to the attorney. Let's go back to your book. Let's look on page 497. So 497 is a sample closing disclosure. And the good thing is this is the same transaction that we just looked at the sample loan estimate. So we could actually do between 494 and 497, we could actually do a nice side-by-side comparison. 494 is what they got 3 days from loan application. 497 is what we're getting 3 days prior to settlement.
Yeah, and I was looking at that, and it was a pretty big difference on the estimated taxes, insurance, and assessments, but yet the escrow estimated escrow and the monthly payment didn't change.
It went up like what, 26 cents, right? Yeah, I've noticed that before too. So I'm not sure how accurate it is.
But going from 206 to 356 is $150 a month.
It's $150, right? Exactly. So I'm not exactly sure where it all came from, but it kind of gives us an idea of what they see. I agree. I'd really like to think that the actual one, not a sample one that the commission gives us, is going to be more, maybe add up.
Maybe they're using Deborah's lender.
How they got that math.
Julie, I think I just put a great story in your quiver for your next classes.
That's right.
I probably just gave you one for the book.
Talk about borrower beware, right? So 497 again at the top, contact information, loan amount, interest rate, I think what we want to see here is that if the information changed, it's still the same loan amount, it's still the same interest rate, it's still a prepayment penalty, it's still a balloon payment. If you come down a little bit further, and this may have something to do with it as too, well, Ronnie, I'm not sure, but your estimated closing costs, you were estimated at 8,000, now you're estimated at 9,700 and change. Cash to close, though, the cash to close has come down. So how much does the buyer actually have to bring to closing? They were told to bring $16,054, but now that we're here, they only need to bring $14,147.26. Again, that breakdown of how we got the $14,147.26 is going to be over on page 499. 498 and 499 is the math that we're getting ready to do. So I'm not going to spend much time on this now. We will definitely spend, but these 2 pages are the settlement statement, giving us the costs, all the debits on 498. The one thing I do want to point out, and this is my favorite part about the closing disclosure, look at the top of page 499. It actually gives the borrower a very nice and convenient side-by-side comparison. This is what you were told in the loan estimate. This is what you were told now at the final. And did this change? A very simple yes or no. So I think that tends to be what borrowers look at, the picture, the big picture kind of from the loan estimate to the closing, and whether or not there was a change or not. 500 and 501 are just the rest of the closing disclosure. Contact information, that kind of thing. So again, this is the math we're getting ready to look at. This will be a big chunk of our day on Monday. So we'll talk a little bit more about that before we go.
Yeah, all of a sudden they found $2,500 in seller credits up there. That was a
that
nice
might have
gift.
been that might have been something that was renegotiated. Yeah, I see what you're saying. Yeah, so that might have been something that was, in lieu of repairs, right? So there's a lot that can happen from contract to closing for sure. So as we have kind of been saying, CDs are just simply that. Closing disclosures are disclosures. They are not settlement statements. Disclosures are just going to disclose the numbers. They're still just going to disclose the information. Closing disclosures don't authorize attorneys to disperse funds. So the closing disclosures isn't how you and I get paid and the lender and the attorney and home inspector and everybody else. So in addition to the closing disclosure, we usually see a settlement statement. And the most common settlement statement that we see is the ALTA, the American Land Title Association. So we're going to have the CD, we're going to have the ALTA. We'll look at a sample ALTA just real quick when we come back from break. But usually the agent won't see the ALTA until we get to settlement. So we can just do a quick look at it to make sure, that the numbers, the bottom numbers still add up from the closing disclosure. So let's bring this home. What's this all about for us? Well, we have a duty to ensure the buyer receives an accurate closing disclosure. Deborah, I don't know if this makes you feel better or not. I have not reviewed many closing disclosures that are correct. Mistakes in these things are common. And this is why it's so important that we help our buyers and sellers verify them for accuracy. Again, guys, I tell you, they don't understand those numbers. You and I do. That's why they have us. So that's why we spend the time that we do working on this in this class. If, or more accurately, when you find an error on the closing disclosure, we have to report it. We need to pick up the phone and call the paralegal, let the lender know if applicable. Usually the paralegal or the attorney will be in communication with the lender. I've seen the wrong earnest money amount. I've seen additional earnest money missing. I have seen my commission missing. Reviewing the closing disclosure on the listing agent, 0 commission on there whatsoever. I called the paralegal. The buyer's agent's name was Mike. I called the paralegal and I said, yeah, Mike and I want to get paid. And she said, and I quote, whoopsie. So I can't imagine what could have happened had I not picked up that phone. And, I picked up the phone pretty quickly, right? I also needed to pick up the phone pretty quickly when I realized the additional earnest money wasn't on there, or the, earnest money was wrong, home inspections missing, whatever. We've got to report those errors. As we said, we're going to notify the lender of any expenses paid by third parties, because all money that changes hands needs to show up on the settlement statement. So failure to report errors and omissions would be considered willful failure to disclose a material fact. This is part of our duty as brokers. The A in old car is accounting. And this would fall under, the closing disclosure would fall under that A for accounting, and making sure that what my buyer has to bring to closing is accurate, what my seller hopefully gets from closing is going to be accurate. All right, let's see. You guys want to set your private chats? Private chat just to me. I got some Q&As for you. Let's see how we did. You guys ready? This is Kahoot as I can get with 2 people. So Respa requires that Respa requires that disclosures be made of all settlement costs. So they have no regulations on how fast closing happens. That's an agreement between the parties. Seller's lender discloses their balance due, or buyer reviews. 2 days, we know that that's 3. An example of a kickback that is not allowed by Respa is an example of kickback not allowed would be a fee paid by a surveyor to a broker for a lead. Again, to or from settlement service providers for a lead. So real quick, let's go back to the Real Estate Commission's website. And our favorite is publications. And another Q&A brochure that we have that I want to bring to your attention is one on closings. So if it's a first-time home buyer, if it's a buyer that hadn't bought a house since the housing market crashed, they might as well be treated like a first-time home buyer, right? Because it's a different process than what it was, back in the 90s or early 2000s. Even if you're working with a seller that has some questions on real estate closings.
Yeah, I purchased my first home in 1987. That's a world of difference.
It was big difference, wasn't it?
Yeah.
I bet. My parents bought their home in 95 and they didn't use agents and and it still makes me cringe. I didn't know what I knew it did, back in 95, but yeah, they went, no, neither one of them were represented. And today we're kind of like, so let's see, does a loan commitment letter guarantee that I have a loan to buy my property? Nope. It just tells the borrower that they've made it through this first round of conversations with the lender. I think this is a really good, I'll let you guys read this. What is title insurance? So this helps explain to the borrower what title insurance is going to be, what it's going to cover, how it's going to protect them for their new home. What if the seller wants to give me a non-warranty or a quitclaim deed? The best one is the general warranty deed. That's what our contract spells out. So if you're given anything then that, you want to immediately consult with your attorney. What happens if the property is damaged or destroyed after I sign the purchase contract? We'll see in our contract that when we look at it, that there's verbiage in there that the property needs to be in the same or better condition at closing as on the date of the contract, normal wear and tear expected. If it's not, the buyer has the option to terminate. We'll see that when we look at our contract next week. Who closes the transaction is probably going to be handled by an attorney chosen by you being the buyer. Again, this is written geared towards the buyer. Certificate of occupancy, if it's new construction or if there was any additional or significant renovations. Addresses the CO. Prorating, we're getting ready to answer that question for you guys. If we don't get it today, we'll talk about it on Monday. Special assessments, what's included in closing costs. I think this is a pretty big conversation for buyers. What can count? Some lenders have different things that closing costs can and can't count for. How can a buyer obtain protection against future liens?
What's the advantage for the seller to pay $2,000 in closing costs compared to reducing the price $2,000?
Because the buyer may need help with these expenses. They may not have this cash laying around. Right. So we can get a loan for the purchase price, but they may not have that much money. This is something else we're going to see coming back when we get out of this market. Right now, for the last couple of years, is the sellers aren't paying anything. But we're going to start seeing that. I remember the last buyer's market we had, when you asked the buyers how much in closing costs, their answer was always however much the lender allows. So the lender kind of puts limits on it. And if they say 3.5%, that's what the buyers were asking for. So we'll see that come back for sure. Good question. How can a buyer obtain protection against future liens? If it's new construction, renovated, or approved property, should consult the closing attorney to ensure the steps to take to prevent contractors or subcontractors from claiming a lien on the property, is kind of addressing our mechanics lien. What are the documents I can expect to see at closing? Here's our CD and settlement statement. What is a closing disclosure statement? Goes in a big explanation about that. Again, I'll let you guys look this over if you'd like. When will I receive my closing disclosure statement?
That statement was longer than our chapter.
Get more information here than we do there, right? Here's our 3 days prior to closing. Can a real estate agent sign closing documents for me? No, not unless you've given them certain written authorization. I don't think it's uncommon if your seller doesn't want to go to closing. I think it's pretty common for the listing agent to have a limited power of attorney in case any of those documents change, then the listing agent can sign, but it's limited. So the only thing you have the access to sign on behalf, and you may want to call your seller and let them know that something changed from when the documents they signed. So that's pretty typical for the listing agents to have of their sellers. Closing attorney is asking me to remit funds via wire transfer. How can I protect myself from wire transfer? We're going to talk about wire fraud when we look at our contract next week, so we'll talk about that. I'm being asked to put something in the statement that is different than what I agreed to. Is that okay? Yeah, probably not. Should reflect the agreement between the parties and match the terms of the contract.
So you're saying that Deborah's ex-husband was not entitled to all the proceeds?
Evidently not, yeah. Let's see, if I'm a seller, when should I get my proceeds from the sale? We're going to disperse funds after closing. The title's been updated and the documents have been recorded. What if I can't close by the time stated? See, they need to update their Q&A, don't they? This is the kind of thing I talk about. When a form updates, it takes a long time for that, everything else behind it. So know now that the contract says the contract is going to override the Q&A, right? So that's right. The contract now says 7 days. And they even list their Q&A brochures on various things. So again, I think these just do a good job putting information in the consumer's hand, helping, especially a first-time buyer or somebody that hasn't bought in a while, helping them better understand the buying process.
But it's 7 days when it's not 4 days.
Unless you check 4, that's right, that's right. And funnily enough, that's only an option in the agreement to amend. It's not an option in the, so it's only if you're changing, if you've renegotiated the settlement date. They keep us on our toes, don't they? If not A, then B and C. Let's see. Let's go ahead. Let me make sure there's nothing else. Let's go ahead and take a break. We come back. I want to look at, spend our last time together kind of looking at some things that we're going to talk about on Monday. I got some stuff I want you guys to look at this weekend to help get us ready for Monday. So let's go ahead. I know we're a few minutes early, but let's go ahead and take our break. And then when we come back, we'll be able to look at that stuff. So I got 3:36. There we go. Let's take 10. All right. While you guys are on break, I put a couple documents in the chat. We're going to look at them. I'd like you guys to grab them. This is part of what I want you guys to look at this weekend. So if you will go ahead and grab them, if you didn't get them, just let me know and I can email them to you. But there's one we're getting ready to look at called Who Pays for What at Closing, and then there's the blank closing disclosure. Before we look at those, we mentioned before break about the ALTA. The closing disclosure is the disclosure. It discloses the numbers. It discloses the terms. The ALTA is the settlement statement. And since your book doesn't give us a sample ALTA, I had to take one from a closing that I had back in 2017. So of course I've blacked out all relevant information. But this is our American Land Title Association, also known as our ALTA settlement statement. And as you can see, it just goes through and it lists all the borrower's debits and credits. So the information on the closing disclosure should also be on the ALTA, right? The two should match. And like I said, we're not seeing this usually until we get to settlement. But that's okay. We can still see it and just make sure everything lines up. The big thing that the ALTA does that the closing disclosure doesn't is it has a place for the borrower to sign. I've carefully reviewed the ALTA statement and find it to be true and accurate of all receipts and disbursements made on my account or by me in this transaction, and further certify that I've received a copy of the ALTA statement. We authorize the attorney to cause the funds to be dispersed in accordance with the statement. So that's what it's doing, is it's giving the attorney permission to pay. And you can see, like, here's the home inspection, the home warranty, homeowner's insurance company, right? It gives the attorney permission to pay these various fees. Since this is the borrowers, our commission wasn't on there, but it's going to be on the sellers because the seller pays commission. So just to give you an idea, you're going to see this. Technically, it is our job as the agent to make sure that the borrower and the seller, for that matter, receives the closing disclosure and the statement. In practice, the attorney is handing that to them when they're at settlement or with their final documents. But it's our job to make sure that it happens. So what another good reason for us to go to settlement is to make sure that the borrower is getting and seller is getting their information. I think what a lot of attorneys are doing now, they may provide a copy of everything unsigned at settlement. They may later provide the signed versions. Maybe they'll email and maybe they'll throw them all on a thumb drive. I think thumb drives are kind of better practices because let's face it, you guys bought a house. What did you do? You bought the house, you walked in the door, you took your closing paperwork and you put it in a box so you could move it. When you got to your new house, you unpacked it, put it in the file cabinet, and you probably never looked at it again, right? So all that paperwork is there somewhere. What they do with it, it's not our responsibility. We just need to make sure that they get it. Assure that that happens. So that's that. What I want to do now is just take some time. One thing I would like you guys to do this weekend is take some time and just kind of look at the blank closing disclosure, kind of what goes where. For your exam, you're going to have to fill out one of these. So I think just taking time and knowing what goes where could save you some time on your test, because a lot of it is hunting and pecking and looking. Do you both have the ability to print? Yes. For your exam, I want you guys to have a blank closing disclosure. So you can print, have some for copies or for your practice that we're going to do next week. But for your exam, you guys will have a blank closing disclosure. Now, I'll need to verify that it's blank, make sure that you start with a blank one. But I just wanted to make sure you guys, and you're welcome to print it front and back, or you could do 2 pages. It doesn't make any difference to me. And of course, I'll remind you about that as we get closer to test time.
It's easier for me to print two pages because I never can remember which direction it goes in the printer to get it everything.
Me too.
Right.
Me too. You know, when I'm at the office, I always print front and back because the copier there is a lot smarter and knows how to do it than you're right, my little desktop here. So, and you know, again, for your test, that's fine. I'll just need to see the back side and make sure you don't have, you know, stuff written down on that. So we just need to make sure that front and back pages are blank. So let's talk about what this closing disclosure, what all is on here. Page 1, everything on page 1 is a debit to third parties. Let's keep in mind the parties to the transaction are who? The buyer and the seller, right? Everybody else is a third party. So everything we see on page 1 is a debit to third parties. And you can see there is different columns here. We'll talk about these in just a second, but there's a borrower paid, a seller paid, and then a paid by others. Borrower paid and seller paid, we can break down even further to paid at closing or paid before closing. So anything that is a debit to the borrower to a third party, or a debit to the seller for the third party, or if it's paid by others, mom and dad paying for the home inspection, for example, that would be a category under paid by others. And the first section up here, section A, is the loan, part of the loan costs, specifically the origination charges. So we'll do a refresher on discount points next week. You'll have your loan origination fee. Section B is the services that the borrower did not shop for. They don't get to choose who the lender uses for the appraisal. They don't get to choose who the lender uses for the credit report. For the most part, what we're going to see is the appraisal and the credit report are going to be paid before closing. So for these practice problems that I'll give you guys next week, unless you're told otherwise, the appraisal fee and the credit report are going to be paid before closing. And in practice, in real world, they're usually paid before closing. So in other words, the appraiser is not going to go out and do their thing until they've been paid.
And in that scenario, are they paid directly by the buyer? Or are they
Yes.
paid, and the other part of my question, or would they be paid by the lending institution since they're the one choosing and then, okay.
Nope. Comes straight from the borrower to the appraisal, appraiser, excuse me. Again, the appraisal is for the lender. The appraisal is actually property of the lender because they're the ones that want to determine that value. The buyer just gets to pay for it. That's it. So they'll allow the buyer to pay for it directly. And they'll share that report with them, of course. Same thing with the credit report fee. The buyer gets no choice in who pulls our credit report.
Yeah.
By the way, anytime, yeah.
And the last time I did a home equity loan, actually the lending institution paid the appraisal and the credit report.
Really?
Mm-hmm.
I've never heard of that.
I'm a pretty good customer.
Yeah, you must be. They said, listen, we're going to do this for him so we can keep him. That's interesting. Anytime you see a blank here that's not filled in, that may just give us an opportunity if there's something here that, we need to add. Every transaction is different, right? So this closing disclosure, I think, covers most transactions, but if you have something you need to add in, that's what we can do here with the blanks. Still under loan costs, this last little section, services borrower did not shop for. I'm sorry, did shop for. So here's the attorney's fee, deed preparation, title insurance, lender and owner's policy. Keep it in mind, the owner, we're referring to the buyer. Today they're the buyer, tomorrow they're the owner. So that title insurance policy is going to cover the new owner from the day they own forward for as long as they've owned the property.
That attorney that left out the broker's commissions, I guarantee has never left off the attorney's closing fee.
Heck no.
Ever.
They didn't have to say oopsie on that, did they? I would agree with that guarantee. Get to shop for pest inspection, survey, again, anything you have. So the way these forms are designed. Each little A, B, and C, you guys see this? The way they would like you to do this is to add up all of A and put the total of A here. Add up all of B, put the total of B here, add up all of C. You see these darker blue? That's how you're usually going to see it in practice when you're looking at a true closing disclosure. When I'm doing them like this, I tend to do them a little bit different. It doesn't matter how you do it as long as you get the bottom numbers down. I don't mess with these darker blue lines. I just tend to add straight down. But again, if we look, let's look back on page 498. You can see how they took the loan costs, added them up, and then they got the 1,802 for A, the 236.55 for B. You guys see what we're doing here? So once on the closing disclosure, once they add up A, B, and C, item D is the total of A, B, and C. So it tells you right here, you take A plus B plus C, and that's the number you're going to get here for D. You guys see what we're doing? Again, I'm kind of a rebel when I do these closing disclosures. When I'm doing them, I don't fill in the dark blue lines. I just kind of add them. I just add straight down. And even for myself, when I'm reviewing them for clients, I tend not to pay attention to the subtotal. I want to make sure that the numbers are right and the bottom figure is right. So I'll tell you guys why. I don't like the way these are set up. When I was taught to add, however many years ago that was, I was taught to add down, right? 2 plus 2 is 4. The way these forms are set up, they have us adding up. And that's what it takes my brain a minute to see. If the loan origination is 2 and the loan origination fee is 2, then add up to get to 4. And that's why I don't like the dark blue lines. Personal opinion. I'm not grading you on how you fill this thing in. I just want to know that you get the answer right, right? It's all multiple choice and you just want to get the answer right. And again, when I'm reviewing these things for clients, I don't pay attention to the subtotals. I just whip out my calculator and make sure that it adds up straight down. So that's the rebel in me. So A, B, C, and D is the total. I'm sorry, A, B, and C. D is the total of all of our loan costs. And then you come down here and you have other costs. E is your taxes and other government fees. So here's our deed and our mortgage recording fees. Here's our excise tax. Prepaids. The borrower, for example, is going to have to pay the first year of homeowners insurance. Interim interest. We'll talk about interim interest on Monday. Any prepaid property taxes or any prepaid PMI, private mortgage insurance. G is our initial escrow payment. How many months of escrow does the lender want to collect to originate that escrow account? We know Respa says 2 months. I'm telling you guys, you're going to see practice problems where it's not 2 months. I think you see one where it's like 6 months of taxes. So don't argue with the problem. If you want to get it right, just do what the problem tells you. You can report that Respa violation later, but do what the problem tells you. And then this last category here is other. So you can see here's our commission, home inspection, warranty, any courier fees, wire transfer fees, anything like that. I is E plus F plus G plus H. So we've subtotaled A, B, and C. We've subtotaled E, F, G, and H. And the bottom line of page 1 of J is the total of D and I. So if you're actually doing it the way it's designed, you're going to add up A, B, and C to get D. Then you're going to add up E, F, G, and H to get I. And then you're going to add D and I to get J. If you do it Julie's way, you're not paying attention to the dark blue lines and you're just adding straight down. Again, I don't care how you do it. Makes no difference to me. For your exam, this closing disclosure is a total of 4 questions. One question is gonna be the buyer's J. Another question is gonna be the seller's J. So what is the buyer's paid at closing total on page 1? What is the seller's paid at closing total on page 1? Questions on page 1.
All right, if you did it not Julie's way,
The right
Where-
way, I hear you.
where it says J for the total up there,
Mhm.
on the seller side, it doesn't have that same blank.
Yeah, and if you look over back to page 498,
Mhm.
I think what they're using there for that blank is the difference in at closing and before closing. But the line right below that where they do have the sellers, they're showing the total of D and I for at closing and before closing.
So the answer would be 12,800 plus 750.
That would be one answer for the sellers. Another question would be the buyer at closing, 9,000. I cannot see that.
97, 12, 10.
Yeah, that number.
But it's kind of strange you don't have the
No,
sellers.
not the 97, 12, 10. The 96, 82, 30
So at closing.
at closing. That's right.
Okay.
So in other words, your test is not going to ask you about before closing numbers, right?
Okay.
Your test is going to ask you what's the buyer's J paid at closing, what's the seller's J paid at closing. And I think what this is here is the difference in the buyers paid at closing and paid before closing. I bet you if we were to take that 96, 82, 30 from 2980, that's probably where we get the 97, 12, 10.
Now you add those two together to get the 97, 12.
Add them together. Yeah. That's what I mean.
Yeah.
Yep. So why is it set up that way? I don't know. Maybe that's another good reason why I don't pay attention to those darker blue lines, because they just don't make sense to me. But for your test, for your exam, we're going to want to see J buyer paid at closing and J seller paid at closing.
Okay.
So there's 2 questions there. Again, everything on page 1 is a debit to third parties. No credits are going to be on page 1. Okay. So if you feel the need of yourself putting in a credit, stop. It's only debits on page 1. When we look at page 2 is between the buyer and the seller. And what I suggest when you guys are looking at this weekend, I suggest you take your paper, and I'll talk about what these D's and C's and C's and D's mean in just a second. But when you guys are looking at these, when you guys are getting ready for exam, I suggest you take your page 2 and you fold it longwise. And we're first going to look at the buyer side. The buyer is on the left. So the buyer has 2 boxes, if you will. There's box K, and then there's box L, as in Larry. You guys see this? Everything in K are the buyer's debits. So what I have done is taken my blank closing disclosure and I wrote a big D on it. So I know that everything is K is due from the borrower at closing. Everything in box L are all of my buyer's credits. So I write a big C on it, on my blank, so I can clearly see all of my buyer's debits and all of my buyer's credits. Looking at K, a debit to the buyer is the purchase price. K3, there's our closing costs from the bottom of page 1. So remember, everything in K is all of their debits, and that includes everything to third parties that we tallied up on page 1. We'll talk about prorating taxes on Monday. So if the buyer is debited taxes, then we will put those in K. If there's going to be an HOA, you'll notice in K, I don't have a place for an HOA, but I do have a blank space that I could fill it in if need be. For example, I got it here on K12. So if there's an HOA that we have to prorate, then we can add that in. And then box L for the buyer is all of the buyer's credits paid already by or on behalf of the borrower at closing. So L1, the deposit, that's their earnest money deposit. There's their loan amount, any seller credits, due diligence fee. And again, if we prorate taxes or HOA, and they're going to be a credit to the buyer, then we will have those under L. So what we do at the bottom of page 1 on the left-hand side, again, just focusing on the buyer for right now, what we have is the total of K and the total of L. All of the buyer's debits minus all of their credits tell us how much the buyer has to bring to closing. Cash to close from the buyer in the amount of, that's going to be your third test question on the settlement statement. What's the cash to close from the borrower? K minus L. And then when you take your paper and you fold it longwise and you look at just the seller, seller's on the right. Box M is all of the seller's credits. So due to the seller at closing, there's their purchase price. Yeah. Do you have a question?
Yeah.
No?
The on line L, the 175,615. Where did we arrive at paid already by or on behalf of the borrower at closing? I don't see where those numbers add up to 175,615.
You're on page 499.
Yep.
Is that not right?
I don't see it. I'm not saying it's not right. I just don't see 175,615.04.
They're taking the 10,000 deposit, the loan amount, seller credit. There's a rebate from Epson Tile Company. Yeah, and then the prorated taxes there. So they're taking everything in L and adding it up. And I just didn't get what they got, but
Okay, again, we're adding up instead of adding down. We're taking those
yes.
numbers, and that's what get plugged into
That's
L.
not how we
Okay.
learned to add, was it, Ronnie? That's what.
I learned on an abacus.
So see, this is an abacus math.
No.
And you know, like I said, I just added them up, and that's not what I got, but I did it real quick. But
Okay.
you know,
All right.
you know,
Didn't mean to interrupt. So we'll
no,
go
no,
back
you're
to the
good. You're good.
seller's side.
But yeah, that's what we're doing is we're adding up. We're taking these figures and looking at this dark blue for K, the dark blue for L. Everything in K minus everything in L tells us how much the buyer has to bring to closing.
I just totaled it, and first time I didn't get it, I went back and did it slower and got the same amount. the second
And
time.
got they did. Okay. And I might have been talking too. Well, we know I was talking. So
That's your job.
that's well, I'll point that out in a second. So the right-hand side is the seller side. So they have their two boxes. M is in Mary and N is in Nancy. M is all the credits due to the seller at closing. So again, there's our purchase price. If it prorated taxes or HOA, if those are going to shake out to a credit to the seller, we'll put those in M as in Mary. And then N is in Nancy is all of the seller's debits. So an excess deposit, which we have an example of that we'll look at on Monday. N2 is all of their closing costs paid at J. So again, everything that we tallied up on page 1 needs to get transferred over to N2. Does that make sense? Because N is all of their debits, and that includes what we got on page 1. Here's their six. I'm sorry.
Yeah, don't have an issue as long as I know where to look for it. And when it says J,
There you go.
Yeah.
All of their payoffs, first mortgage loan, second mortgage loan, third mortgage loan, if we need to write that in, due diligence fees, seller credit, and then again, prorated taxes and HOA, if it's going to be a debit to the seller. Add up all of the seller's M, add up all of the seller's credits, add up all of the seller's debits in N. Credits minus debits tells us how much the seller hopefully is going to get from closing? Could that number be a negative?
Absolutely.
Yeah, absolutely. And if that negative, if they have more debits than credits, then they got to bring money to closing. So for your exam, your 4 math questions from the settlement are the 2 on the bottom of page 1, and then the 2 on the bottom of page 2. I think, Ronnie, kind of to your point, this is part of why I want you guys just to spend some time this weekend looking at the blank. I'm telling you, it'll go a lot faster once you know what goes where, right? Because otherwise you're going to be hunting and pecking. And, so if we can get you looking at that this weekend, then that'll help on Monday. The other thing I want to point out, I do, and I still, how many years I've been doing this, I still write my D and my C and my C and my D, so I can, see what I'm looking at my closing disclosure. But remember, we just started talking about a little bit about proration. We'll talk about proration on Monday, of course, but with proration, it's going to be a debit to one party and a credit to the other, right? So you're either looking at a debit to the seller and a credit to the buyer, or a debit to the buyer, credit to the seller. If you're looking at page 2, if you now fold it this way, if we're prorating, taxes either go here or here. They either go in the top, they would either go in K and M, or L and N. Debit to one party, credit to the other. So that's why I like using this and using my D's and C's, because it helps me see the buyer's debits and credits, the seller's credits and debits, but it also helps me see those prorated taxes. Again, HOA dues are going to be a write-in. What I was going to tell you earlier, the real estate commission, let's see, back on page 490 and 491, they give us a sample or a closing disclosure problem. Y'all go ahead and cross that out. This is not one of the problems that we're going to do in class. They even tell us in here that this isn't accurate. This isn't, there may be things in here that aren't according to North Carolina. So, I mean, they even tell us that this isn't a good one. So don't worry, I got closing disclosures for you guys, the ones that we're going to work in class. I'll have a homework recommendation. I can't give mandatory homework assignments, but I can give a homework recommendation that'll also help you get ready for your exam. So we will do one together on Monday. I'll have a homework recommendation for you guys to do that we will look at again the following Monday. So you'll have a whole week to do that one, and then that'll get you ready for your test. Your test has a total of 6 math questions.
All right, we missed Wednesday in there.
Yeah, I'm giving you a whole week.
Oh, wow. Okay.
Yeah. Yep. So we talk about it on Monday, and then that'll be a good opportunity for us to refresh it and talk about it again the following Monday, right before your test. Yep.
Okay.
Yep. Your test is 6 math questions. 4 of them are from the closing disclosure. 2 of the other math questions are going to be prorating. So just knowing how to prorate can get you, a good amount of questions. And again, we'll look at that math on Monday. Questions on the blank CD, and bring one of these on Monday too, if you guys would, so we can go through and work it together. Okay. The other thing I put in the chat for you guys, let's call this our little cheat sheet. Half the battle is knowing what's a debit to whom, what's a credit to whom, who's responsible for what. And so not only knowing what is on the closing disclosure, but also knowing who is typically responsible for paying what at closing. Please, please, please always do what the problem tells you. So unless the problem tells you otherwise, for example, commission is going to be a debit to the seller. But if the problem tells you that the buyer is paying commission, do what the problem tells you. So this worksheet, this little cheat sheet, if you will, is only typical things unless you're told otherwise. I encourage you guys to use this up until your test. I cannot let you use this on your test, but this gives us a nice little breakdown. Again, help us identify debits and credits for buyer and seller. So seller debits, seller is going to be responsible for paying commission, deed prep, and excise tax. And I've always said, if you can remember your alphabet, then you can remember CDE, commission, deed preparation fee, and excise tax. In addition to CDE, the seller's responsible for paying off their existing loan for delinquent real property taxes. So for example, if they never paid last year's taxes, they're going to have to pay those at settlement. And then any delinquent and current personal property taxes. The buyer's debits, they have their homeowner's insurance. When they originate their policy, let's pretend that we're going to closing today. If we're going to closing today, the buyer's homeowner's insurance policy kicks in today. And at settlement, insurance is always paid a year in advance, right? So at settlement, the buyer will pay homeowner's insurance for their first year. Now, between now and July of next year, they'll have 1/12 of their annual insurance put into their escrow account. So when the bill comes due next year, the lender will pay it on their behalf. But at settlement, they'll have to bring this first year's bill with them. Anything to do with the buyer's loan is going to be a buyer debit. So here's our loan unless we're told otherwise. So here's our loan origination fee, discount points, interim interest. We'll look at that. The buyer pays the recording fees. The buyer pays to have their brand new deed recorded. They pay to have the lender's deed of trust recorded. I want to make sure we see the difference. This tends to be a problem topic here. The buyer pays to have the deed recorded. The seller pays to have the deed prepared. I always remember it this way. When the attorney is getting the deed ready for closing, when they are preparing it, it's still the seller's deed. So they're going to pay to have it prepared. Whose best interest is it to get that brand new deed recorded? It's the buyer's best interest. So they're going to pay to have it recorded. You guys see the difference there? Seller pays deed prep.
So with the seller, would deed prep include the title search?
That may fall under the attorney's fees that the buyer pays, because it's in their best interest to have a clear title, right? So the only thing we're paying here is to prepare the deed. As you can see down here, we got a buyer debit for closing attorney fees. Definitely going to be a lot more for the buyer than the seller as far as paying the attorney. Let's see, other buyer debits, title insurance, both the owner and the lender's policies. The buyers get to pay for both. By the way, I don't think I said this earlier, so let me make sure I say this now. Title insurance is a one-time fee. It's not like they have to renew it every year. So they pay it once at closing and it gets them through. The buyer as long as they own, the lender as long as there's an outstanding mortgage. Buyer's debit is a survey, the closing attorney's fees, there's our advance escrow deposits, however many months the lender wants to have in the escrow account. Home inspection, pest inspection, radon, well, septic, anything that the buyer has inspected or investigated. Private mortgage insurance. So if it's a conventional loan with a loan to value ratio of 80% or more, there could be private mortgage insurance.
But wouldn't that normally, but the PMI, wouldn't that normally be part of the monthly payment as compared to something that the buyer would bring to closing?
Sometimes. We're going to see some examples on Monday that the buyer brings like the first year of PMI. to closing. The lender requires the buyer to bring that. Sometimes they roll that into the mortgage, and they might after the first year. But remember, I don't have any money in the escrow account right yet, right? So it might be that they require the first year to come to settlement, and then we'll start collecting a 12th. So then next year we have it in the account.
Okay.
Yep. And then we got our POC as a reminder here, paid outside of closing, or as we saw in the closing disclosure, actually belonging in the borrower paid before closing. So paid outside of closing, borrower paid before closing, appraisal and credit report. Buyer's credits, the earnest money deposit is going to be credited to the buyer. Remember we told them we went under contract, you pay this earnest money deposit, it will be credited to you at closing. So we need to make sure that we do that. Another credit to the buyer at closing is their loan amount. Let's talk this through for a second. The day of settlement, the lender is bringing money on behalf of the borrower. So the day of settlement, if you will think about our settlement statement as a snapshot of today being the day of closing. Can the buyer close without that money? Can they close without the loan from the lender? No, they need that money, right? So the lender is bringing that money on their behalf. The day of closing, the loan amount is a credit to the buyer. Tomorrow and for the next 30 years, it's a debit, right? They're going to spend on the next 30 years paying the lender back. But the day of settlement, that loan amount is a credit to the buyer on their behalf. Here's our prorated. Again, we'll talk about this on Monday, but with proration, it comes down to whether things are paid or not paid at the time of settlement. Credit the seller, debit the buyer, for example, and the various things that we can prorate. We'll spend a little bit more time we'll spend more time talking about this on Monday. And then we have double entry items. Things that are double entry items are things that are going to show up twice on the settlement statement. So a double entry item, for example, you have the sales price. The sales price will be a credit to the seller and a debit to the buyer. The buyer is paying the seller the sales price. That's the whole gist of our contract, isn't it? I promise to pay you X amount in exchange for your property. The due diligence fee is going to be a debit the seller, credit the buyer. When we went under, are either one of you an accountant or have an accounting mind?
Oh, hell no.
Goodness. Okay. I bet you know this though. How do you clear out a debit? What's the opposite of a debit? It is a credit, right? So in accounting terms, if you have a credit to clear it out, you need a debit. If you have a debit to clear it out, you need a debit. So let's talk about the due diligence. When we went under contract back in the day, didn't the buyer give the seller due diligence? Didn't they hand them a check? So back in the day when we went under contract, it was a debit the buyer, credit the seller. Now that we're here at settlement, we need to reverse that. So we cancel that out. So we zero that out. So that's what we're doing now. And again, we told the buyer when we went under contract, you pay this earnest money, you pay the due diligence. If we get to closing, they will be credited back to you at settlement. If the buyer's assuming the seller's new loan or doing owner financing, debit the seller, credit the buyer, transfer the seller's escrow account, the tenant situation, there's our security deposit, or anything separately sold outside, credit the seller, debit the buyer. The buyer's paying the seller for, the dining room furniture or the Jag in the garage, or whatever personal property.
Yeah, my last one, the John Deere was included.
Was that it? Was it?
Yeah.
So any of that personal property. Yeah.
But as far as being an accountant, I'm very comfortable with P&L sheets and financial statements. But if it come down to me being a CPA, I would rather jab my eyes out with pencils.
Agree. I'm married to one, and he comes home someday and I glaze over. I'm like, I mean, it's just, so somebody's got to do it. He loves what he does. So I'm like, hey man, go nuts. We need more of him out there. But me, on the other hand, I tell you, it's an advantage as a real estate agent to be married to an accountant though, because I just got to hand him my shoebox every year pretty much and say, here you go. So that's nice. There are perks there. So again, just kind of your little cheat sheet, help you guys. If you can look at this and you can look at this weekend, then it'll kind of get us better position for Monday. We're not spending as much time hunting and pecking, and then you're getting yourself familiar.
All right.
For what we're going to do for the test.
If my download didn't go through, is it okay if I reach out to you to email it to me?
Of course,
Okay.
of course. And
I think it went through, but I won't know until
blank
we log
closing
off.
disclosure is in Learn Test Pass, so it's in
Oh,
the
okay.
6B. This is not though. The
Okay.
who pays for what is not Learn Test Pass. So please, if you didn't get it, please email it to me and I'll be happy to respond. Yep.
Okay.
I can tell you, Ronnie, when I downloaded it, for whatever reason, my computer did not automatically save it as a PDF. So I had to go back into the file where I saved it, right click, rename it, and just put .pdf at the end.
Mhm.
It didn't recognize that it would let me open it, but it wasn't letting me open it. Whatever, it comes as a PDF on her attachment, but it
Yeah.
will not automatically save as a PDF.
Let's just say Zoom can be quirky. I've had some people whose devices will not receive an attachment when I put it through the chat like that. So
Okay.
yeah, if you didn't get it, or Deborah, if you weren't able to save it, please just reach out to me and I'll respond. Just
No,
like
I'm
that.
good now. I just changed the file extension to .pdf and it's fine. I've already
You had to
printed
kind
it.
of
I'm good.
manipulate it a little bit.
Yeah.
So again, in Learn Test Pass, where we're going to go next week, if you guys want to look ahead, you're welcome to. This is the one that we're going to work in class together. So if you just kind of want to peek ahead, and even if you want to take a step further and say, this is a debit, that's a credit to the buyer. So you know what I'm saying? Just kind of peek ahead. This is the one that we're going to work together on Monday. And then under 6B, we got the blank CD there, but then there's some extra practice problems. And one of these is your recommended homework assignment. I want to say it's number 4 that we're going to have, but any of these that you do for practice is going to be helpful, get you ready for that exam. So everything we're going to do next week is here. If you want to look ahead at it, you're welcome to. If you want to wait, then we'll talk about it on Monday. Again, all I ask is that you just take some time to familiarize yourself with who pays for what at closing, and then to help you guys for the test, kind of familiarize yourself with the blank CD and what is where's commission, where's the home inspection, because that could save you, time from hunting and pecking and looking from every single thing. Comments, questions?
Nope.
Any concerns? How are we feeling?
Are we talking about just this course or in general?
How about specifically just the closing disclosure?
No, I don't feel as good about my account with Truist now.
Oh. Just don't come on for a refi, right? Well, guys, I know we stayed a little bit later yesterday and we're at a really good stopping place. So I'm going to go ahead. We're going to boogie a few minutes early today, if that's all right with you guys. You guys have a wonderful weekend. Please never hesitate to reach out to me. If you're reviewing anything this week or looking ahead and you have any questions, please don't hesitate to reach out to me. Let me help. Otherwise, you guys have a great weekend and we will see you at 11:30 on Monday.
Thanks, Julie.
Thanks.